Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Not he Anglican for, he's verbal slaughter.
Is that correct?
I didn't ask you to interrupt me.
That's literally not true.
Oh, for God's sake.
Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. Sorry, all my stuff shut off this morning, and everything is completely messed up. But we're here. I feel like I'm sitting in the dark for some reason, because the camera readjusted. It's no bueno. Let's get that fixed first. Let's see. Give me a little more light. There we go. Does that work? It's not too grainy. I hope. Can't even see it here. Hang on. I think that'll work. All right. We are here. Man, that's loud in my ears. I'm not sure why. All right. Good morning. Great to have you all here. It's Thursday, and it's a podcast Thursday at that. I'm sorry I was late for a couple of reasons, not just because my stuff shut off. But I had to run to the store to pick up some stuff for today's demonstration. So we got a we got a bottle of Rain-X. We've got some red Powerade. And I've got some liquids in these two bottles, so we'll play a little science today and do a little color mixing and see what we can come up with. All right, but I'm not drinking anything from RA's house. Okay, it looks sus. Trust me, we're not going to do anything dangerous. Not doing anything dangerous. The Rain-X is only purchased just to get the color. I needed the color. And I bought this one also because it says it's 2-in-1 de-icer and bug remover, which has become very important in North Carolina in the last, 2 weeks. I don't know what bug hatched and grew to maturity, but it's flying around the freeways and is coating our cars. So this is for Mrs. R.A., but for her car. Make that clear. It's for her car. Bittering agent? No. At least not by law. I see nothing about a bittering agent on here. Zero. There should be. All right. Good morning. Hope you're all doing great. Don't be suspicious. That's what I use. It works well. Driving back, let's see, where do I go? We went to Rocky Mount on Sunday, and Mrs. R.A. was with us. And when you drive from Rocky Mount to Greenville in North Carolina, it's basically one long country road the whole way. So it's not like freeway, exit, things like, no, it's just like a 2-lane road with fields on the side. And so it was just, full-grown grasshoppers, dragonflies, massive June bugs, and anything larger than about an inch, we were hitting on the windshield. And it just coated our car. And I completely ran out of windshield wiper fluid on the way home, and it wasn't doing the trick. So anyway, we'll get to that in a little bit. But you got red Powerade, no Fanta. I should have got Fanta. Maybe there's still time. All right, there isn't. We're late. Does Mrs. R.A. know it's for her car only? Yes, made it very clear. Talked to all the kids as well to explain what was happening, what was not happening today. And let me make it clear for you, just in case you have any concerns. What is not happening today is I will not be mixing any dangerous substance with any edible substance. Period. End of story. Let's see. Francis Fitzgerald won the internet and chat's not on screen. Oh, Yeah, it is. Yeah, it is. Sorry. Thank you. We're just doing color matching. That's all we're doing today. And all of our color matching materials are drinkable. Well, drinkable if you like Powerade Zeros. So we have Powerade Zeros here. This is not any cleaning agent. This is not any antifreeze. This is just Powerade. But we took the label off so we could see the color clearly. All right. With that, I will not be opening the Rain X on the show. With that there will be no making of sandwiches in honor of Corey. No. Although Lori's green chili enchiladas, I think I made them better. Yeah. All right. Let's go where we need to go, which is we need to celebrate some birthdays, and then we need to get to court because we're behind. And now's not a day to be behind. So here we go. Chuck Norris, thank you very much for the birthday messages here. Amy, April, Jean, Nicole, and Sandy. Did I pronounce all those right? Thank you for having names that are easy to pronounce. Amy, April, Jean, Nicole, and Sandy. We're about to sing to you, and by we, I mean all of us, wherever you are. If it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with a neighbor, and warm up with me if you will. La, 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 la. We're good, we're ready. Happy birthday to you. Happy birthday to you. Happy birthday, dear Amy, April, Jean, Nicole, and Sandy. Happy birthday to you. All ladies today. No guys slipped in their birthday today. It's just a ladies' day only. But Amy, April, Jean, Nicole, Sandy, there are many wonderful days, but today is your special day. I realize there are a million places you could be and a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully you're going to turn that joy back to you, make your day just a little more special. And begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Andy's Grill, Bob Evans, and Cracker Barrel. First time. No mess-ups that time. Happy birthday. Happy birthday. Jennifer is doing all the dancing. And she's shaking it. Jennifer, we're impressed. We are really impressed. Happy birthday to everybody. Ooh, and a guitar solo even. White Rabbit. I like it. What a great addition. Little jazz hands finish. I hear you, Vern. I hear you on the party horn. Cauliflower as well. Going at it with the party horn. Awesome. Happy birthday. Happy birthday. I hope you have a wonderful day. Honestly, all of you. Thank you very much for being here. There's lots of places you could be. It's a privilege to see that you're here with us. Francis Fitzgerald blowing the party horn as well. Drum solo. Okay, all right. We're done with the party horn. All done. All right, happy birthday. I sort of messed up the drum solo as well. We have to go back to court because court is starting without us, and we do not want to get too far behind. That would be bad. Okay, do we have sound? Yes. Do we have picture? Yes. There we go. Perfect.
Good morning. We're back on the record with case on trial. Our jurors are lining up.
So we've got our witness ready to go?
Yes, Your Honor.
And I understand there have been some various issues with the virtual testimony by the defense witness, but that he's going to be appearing tomorrow in person?
Yes, that's
What?
correct, Judge.
Okay.
Okay.
We've told him if there's any problems, he had transportation issues, we said we'll send a car, we're going to have him here.
He doesn't have a
Mr.
car?
Scully is with another witness, Judge, why he's missing at the moment.
All right. That's fine.
Mr. Scully's with another judge? Your main client's on trial for murder. I almost said wife. Not that wife. No. But your main client's on trial for murder. I'm not sure what you have going in another courtroom, but this is rather pressing.
I don't know if I have that in here or not either.
What trial is happening in Mississippi today? Does anybody know? What's the Mississippi trial? Kate, happy heavenly birthday to your brother.
Poke me if I forget. Definitely on my list.
Okay, so you should have
Poke me if I forget.
I don't really have a list for you.
What trials in Mississippi? Anybody know? Don't make me ask Grok.
I knew I'd find that. No, she said that.
MISSISSIPPI. Jeffrey Spence. All right, Spence, huh?
Come right in.
What are we waiting for?
Good to go. You can come right in.
Oh, man. Seriously, Judge? We've gone all morning without anything and then that. Okay, so that's going to be number 7 and 11.
All rise for the judge.
I have to set it up again because it's not on screen.
Be seated.
Morning, jurors. Since we saw each other yesterday afternoon, has any member of the jury discussed the substance of this case with anyone, including among yourselves? No. Since we last saw each other, has any member of the jury seen, read, heard, or overheard anything from any outside source? No. On any aspect of this case? I thought I was going to get through that without calling. The answer to that question is what? No. Thank you very much. We are proceeding with the presentation of the Commonwealth's case, and I think we're about to call their last witness. Mr. Camilio.
Thank you, Your Honor. Commonwealth calls Richard Atkinson.
Give me a second to get the counter working. It's not playing nice. Oh, there's another. That's 712 now. It's 13. Who's got the candy?
Going to ask you to stand behind
the judge.
Sir, if you'd raise your right hand for me, do you solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Thank you. You may be seated.
You come along. Make yourself comfortable in that chair.
Good morning.
Good morning. Good morning, sir. In a nice loud voice, could you introduce yourself to the jury and spell your last name?
Sure. My name is Richard Atkinson.
That's loud enough, sir.
Atkinson.
And sir, what do you do for work?
I'm a medical examiner or forensic pathologist.
Okay. Ooh. And what is, I'm just going to use the medical examiner term. What is a medical examiner, sir?
A medical examiner is a medical doctor who examines the bodies of people who are deceased to determine the cause and manner of their death.
Okay. And in order to become a medical examiner, sir, could you tell us about the training that was required in order to become a medical examiner?
Sure. I have a bachelor degree from Stony Brook University. I then did a 4-year MD at Columbia University College of Physicians and Surgeons. I then did a 3-year pathology residency at New York Presbyterian Hospital and Stony Brook Hospital in New York. And then I did a 1-year fellowship training in Boston at the office where I currently work, the Office of the Chief Medical Examiner. And that fellowship was specifically forensic pathology training.
All right. What is forensic pathology?
Forensic pathology is the branch of pathology that's involved with deaths that have a medico-legal, you're trying to find out the cause and manner of death in sometimes cases where that go to court.
Okay. And you used the term medical legal. Does that sort of distinguish forensic pathology from sort of the things that I don't know, I'll call them normal doctors, but doctors who are not medical examiners or forensic
You're not a normal
pathologists
doctor.
do?
Sure. Other pathologists that work in hospitals do autopsies on people, but it's generally people who have natural causes of death who died from diseases, whereas medical examiners examine the bodies of people who die in possibly suspicious circumstances from unnatural causes, injuries, poisonings, drug overdoses, that kind of thing.
So,
Drug overdoses of poison.
in addition to the medical training that is necessary to become a doctor and become a pathologist, you also need to be familiar with the way certain objects, guns, knives, projectiles can damage the body, or other substances can cause harm to the body. Is that fair to say?
Yes.
Okay. And is that how do you get that sort of training, sir, for that part of your job?
That training is during the year of forensic pathology fellowship, and then I've also worked for 11 years now in addition to that as a medical examiner.
Okay. And do you continue to study those types of things over the course of those 11 years? Do you continue to study other cases by other medical examiners, other ways that death can be caused in your work?
Yes.
Okay. Now, I want to, I'm going to turn your attention to a specific autopsy that you performed on November 14th of 2022, an individual named Leroy Fowler. Are you familiar with that case, sir?
Yes.
Okay. And in connection with that case, you performed an autopsy?
I did.
And wrote a report?
Yes.
Ordered a number of tests to be done in connection with the autopsy?
Yes.
And then examine the results of those tests in informing your conclusions in this case?
Yes.
Did you also have access to Mr. Fowler's medical records?
Yes.
And did you review those?
I did.
Okay. And did you also have access to information about the circumstances that were known at the time regarding Mr. Fowler's death?
Yes.
And you take all of that, combine it with your training, your experience, and then your job is to determine, among other things, the cause of the death of Mr. Fowler, correct?
Correct.
All right. Now, I want to ask you a couple questions, sir. Are you familiar with a substance called ethylene glycol?
Yes.
What is ethylene glycol?
Ethylene glycol is a compound that's present in antifreeze, among other common items that you can buy at the store. It's a colorless liquid. You can't smell it, but it tastes, when it's by itself, it tastes sweet.
Okay. And is ethylene glycol something that you have familiarized yourself throughout the course of your career in order to do your job as a medical examiner?
Yes.
Okay. And have you studied cases of prior ethylene glycol poisonings prior to becoming involved in this particular case?
This is the only case I've ever personally had.
That was a bad question. I'm sorry, I didn't interrupt you. But as in forming your conclusions in this particular case, in doing your autopsy and in arriving at a cause of death, did you study for this particular case, in this particular autopsy, the way ethylene glycol can be used, can affect the body in order to reach the conclusions you're talking about today?
Yes.
Okay. Would that include the study of criminal cases that involved ethylene glycol poisoning?
I did look at some of those, yes.
Okay. Now, how does ethylene glycol get into a body?
All of the cases that I know of, ingested by mouth.
So it's you drink it. Someone drink
Generally,
it.
yes.
Okay. And the fact that ethylene glycol, as you said, by itself is sweet, was that significant to you in the work you were doing in this particular case?
Objection, Judge. I think that's beyond the scope.
I'm going to permit him to say yes or no. We'll see where that takes us. You may answer, Doctor.
I considered it, yes.
Okay. And why did you consider it, sir?
If it's sweet, it's easier to mix with another sweet drink that somebody might not notice that it's there.
Okay. All right. And with regard to tasting sweet things or other objects, does that vary among individuals? The ability to taste certain things, taste sweet things, taste bitter things?
Objection, Judge. I think that's beyond the scope as well.
Well, let me see your sidebar. I just want to make sure I understand.
All right.
Objection.
Well, oh, man. Seriously, got one more cough in right before we went to sidebar. Okay, 7:22. Well, that discussion was going on. I was just, I was having my morning beverage. I like to have a little bit of fruit punch Powerade in the morning, drink about half the bottle. Didn't like the fruit punch flavor today. It just wasn't.
The bar sucks anyways.
Yeah, the bar does suck anyway. Who said that? Northwest. So I added a little bit. I added a little bit of a little bit of yellow to it. Half a bottle of yellow and half a bottle of red. Still did not change the color of the red Powerade at all. So I drank half of that and then added about a quarter bottle of orange to it, and it's basically still red. It still is almost identical. You can barely tell a difference between these two. But it does taste better than fruit punch now. I think she used different antifreeze, and the Rain-X was a red herring. Rain-X here is a very different color from the red. Now, I was talking when I stopped in at the auto parts store this morning to talk to them about antifreeze and what colors they had available. Kaiman Water's Edge. Hi. No, you don't need to be a member. You just need to catch my attention, and I'll say hi for sure. When I stopped in at the auto parts store to get the Rain-X for my wife's car this morning, I was standing for a little while in front of the
hello.
Do certain medical conditions affect
shelf.
people's ability to taste?
Hang on. I'll tell that story later.
Okay. What sort of medical conditions can affect a person's ability to taste substances that they're drinking or eating?
Judge, I would object again. It's a medical examiner who's testifying here.
I'm going to sustain the objection unless you lay a foundation for Dr. Atkinson's expertise in this particular area.
Okay. Is the ability to taste something that you studied in medical school and during the course of the rest of your medical training that you've had over the last 15, 20 years or so?
Yes.
Okay. And is that something that is generally taught at medical schools?
Yes, it's losing your taste is a symptom of many diseases. So of course we learn about that.
And what sorts of diseases or other things can cause a person to lose the ability to taste when they're drinking or eating?
Again, objection, Judge.
I will overrule it. I think a foundation has been laid. You may answer, Doctor.
Several things can. One thing that comes to mind is viruses, viral illnesses can cause either a transient loss of taste or smell or sometimes permanent.
Anything else?
Yes, several other things. I can't think of any right now.
All right, Doctor. I want to move over to the particular autopsy that you did in this particular case of Mr. Fowler. Right? Can you explain to the jury real quickly what do you do during an autopsy? What are the steps?
Sure.
Take
In
the
an
insides
autopsy, we
out.
examine the external surface of the body first and photograph it to look for signs of injury or disease that could have caused the person's death. We then do an internal examination where we cut into the body, examine all the organs, also to look for those things. And then, importantly, we take samples of the body to either test for fluids from the body or tissues from the body to test for things like toxicology or microbiology. Sometimes we look at tissue under the microscope. All of these things to come to the diagnosis. And then we also often look at medical records because those can help as well.
All right. Now, in this particular case,
Thank you for tuning
had
in,
you looked
Pam.
at least
Appreciate
some
it.
of the medical records or
Love that you're
received
here.
some information from the hospitals where Mr. Fowler had been before starting your autopsy?
Yes.
Okay. So is that helpful for you for a particular reason? Do you want to know something about the history of the patient, not a patient, I guess, by the time they get to you, but the history of the person you're performing the autopsy on before you start?
Yes, any information is useful.
Okay. And so you performed the external examination of Mr. Fowler in this particular case?
Yes.
Anything that was important or relevant that you noted on the external examination?
The external examination was not particularly important. He had a scab on the top of his nose, some ecchymoses or bruises on one of his arms and both of his legs that I wasn't sure if they were bruises from trauma or from needles that he might have gotten during medical therapy.
None of the things that you noticed or just described for us that were on the external examination appeared to have anything to do with his cause of death. Is that fair?
That's fair.
Okay. So after the external examination, you move on to the internal examination. Is that correct?
Correct.
All right. And what does that consist of, sir?
That consists of removing the organs, the major organs of the body, and examining them to look for signs of disease.
All right. Now, when you did that in this particular case, did you make any findings or notice anything on the internal examination of Mr. Fowler that was important to you in reaching your determination as to cause of death?
Yes.
Okay. Could you list for us, and then we'll go through them, what were the things that you noticed during the internal examination that were important to you in arriving at a determination as to cause of death?
Sure. His brain was very swollen. When you think of a brain, it has something called sulci, which are little grooves. If you've seen a brain, I'm sure you know what those are. When the brain swells,
Not many of us
those
have.
become flattened, and so the surface of the brain is more flat. So that's the first thing I saw. Also, his brain stem, that's the portion that eventually becomes the spinal cord in your torso. The brain stem had hemorrhage in it, which you see when someone has a swelling of the brain that eventually kills them. He also had heart disease. His heart was enlarged. He had a bicuspid aortic valve. That just means it's one of the valves in the heart. A normal aortic valve has 3 cusps to it. People are sometimes born with aortic valves with only 2, and this is called a bicuspid aortic valve. It can cause issues with the heart. He also had atherosclerosis in his coronary arteries. That's just coronary artery disease, blockage of some of them. It wasn't super severe, but it was there. And then very slightly fatty liver disease. And finally, his kidneys were discolored and had a granular looking surface.
Okay. So let's start with the brain swelling. You said that the brain was swollen so that the folds in the brain were sort of flattened out?
Yes.
Okay. And why was that significant to you, sir?
That's a sign that the brain was swelling for some reason.
Okay. And sounds obvious when I say it, but brain swelling is not good.
Not good.
Okay. And in fact, brain swelling can cause death.
Yes.
Okay. Now, the brain stem hemorrhage, that's connected to the brain swelling?
Yes.
Okay. What does the brain stem hemorrhaging tell you?
It's what's called secondary brainstem hemorrhage, or also known as Durée hemorrhage.
Okay.
It occurs when the brain swells to the point where the cranial cavity in your skull doesn't expand its bone. But when the brain expands, it has to go somewhere. And there's a large hole in the bottom of the skull called the foramen magnum. That's just Latin for large hole. And that's where the brainstem normally goes through and becomes the spinal cord. When the brain swells, there's nowhere else for it to go but downward. So the brainstem, which is wedge-shaped, gets wedged into the foramen magnum and gets basically strangulated and dies. And that's why you see that hemorrhage.
Okay. So the brain swelling and the brainstem hemorrhage, were those directly related to his cause of death?
Yes.
Okay. Now, you mentioned that there was he had an enlarged heart with the bicuspid valve?
Yes.
Okay. Did that have any effect on his cause of death?
In this case, I don't believe so, no.
Now, the coronary artery, the partial coronary artery blockage, you said that it was not, I don't want to put words in your mouth, but you said not that severe, but it was there?
The most blocked that any of the 3 main coronary arteries were was 60%. You don't generally even have symptoms of coronary artery disease until 75%. So it was moderate occlusion of the coronary artery.
Right. So not particularly a good thing, but not related to Mr. Fowler's cause of death?
Right.
The liver issues that you noted, what were those again?
Just mild hepatic steatosis, which is just fatty liver disease.
Did that have anything to do with his cause
They
of death?
always want to use the
In this
Latin,
case, I don't believe it
the
did.
Latin.
Okay. And
And
then
the
you noted some
big words.
injuries to the kidney, correct?
Yes.
And what were those injuries to the kidney, sir?
Well, it had a mildly granular surface. You can see that in hypertension, which is also why you have an enlarged heart. I believe he had hypertension. But more importantly, there was just a discoloration to the tissue of the kidney, which I wasn't, you can't tell what it is just from looking at the kidney, but I looked at it under the microscope.
Okay. All right. So when you looked at the kidney under the microscope to look at that discoloration, what did you find?
I found something called acute tubular necrosis. That's just when the tubules in the kidneys all die.
They die?
Yes. And also more importantly, or also important, the kidneys under a polarized light filter on the microscope showed numerous crystals.
What kind of crystals were they, sir?
These crystals were calcium oxalate crystals.
Okay. Sir, I'm gonna hand you 4 pieces of paper that contain 5 images. I'm just ask you to take a look at those, okay?
Sure.
Do you recognize those images?
Yes.
What do you recognize them to be, sir?
These are images that I took of the microscopic images of the kidney that I included in the autopsy report.
All right. And do these photographs depict the calcium oxalate crystals that you just mentioned to the jury?
Yes.
Your Honor, I offer these as the next, there's 4 pages exhibit.
Any objection? No objection. They may come in. Thank you.
And doctor, which one of these images here is the one that best depicts the the calcium oxalate crystals that you just mentioned to us?
Different ones depict different things. This one kind of shows the extent of how many crystals there were.
All right, let me start with that one then.
Okay.
I'm going to just put this up.
Which number is that, Mr. Camilio?
This, thank you, Judge. This is 64. If we can get the autofocus to work. All right, there we go. And so the white, sort of the white, yellow, red-ish objects on the black background, the colored objects there, those are the crystals that you're talking about?
Yes, on this screen it just looks like black and white.
Yep.
The black is what it would look like with no crystals because the light is polarized to where you can't see any of the kidney, and the crystals are the white that you can see.
Okay.
So that's how many there were in this area of kidney.
And should there be any crystals in that area of the kidney?
No.
Oh, I leave the other side. Let the other side. What do some of those other photographs show that you can't see in this one, sir?
They show the kidney architecture because when you zoom in, even the polarized light allows you to see the kidney again.
Okay.
And it shows more crystals up close so you can see their shape better.
Okay. And the damage to the kidney that you just described for us, the acute tubular necrosis, is that visible in these types of images?
You would not be able to tell by looking at any of those.
All right, thank you. Now, calcium oxalate crystals in the kidney, is that so they're not supposed to be there, right?
Correct.
Okay, so that's concerning for you, something that you then look at in more detail in connection with the autopsy, is that right?
Yes.
Okay. What based on what you knew about Mr. Fowler's presentation at Anna Jake's Hospital, Mount Auburn Hospital, and Beth Israel, combined with the calcium oxalate crystals that you found in the kidney, What were you now investigating as his cause of death?
So if I had discovered these calcium oxalate crystals in the kidneys, not knowing anything else, that would immediately make me think this might be an ethylene glycol poisoning case. That's the first thing that comes to mind.
Okay.
But I knew additional information before that, so I already knew to look for them.
Okay. What sort of additional information did you have, sir?
I knew from the medical records that the physicians at the hospital, one of the hospitals where he was treated, had seen calcium oxalate crystals in his urine, and that he had many other findings, lab findings, and symptoms that all match up with ethylene glycol toxicity.
All right. And that would include the anion gap, an osmolar gap, and metabolic acidosis, among others?
Yes, among many other things, okay. Yes.
All right. So in order to sort of continue to explore, what you said was the first thing that popped in your mind is ethylene glycol poisoning. Did you send out for testing a blood sample that was taken at Anna Jake's Hospital a little bit after 9 a.m. on November 11th, 2022?
Yes.
Okay. And what did you request that be tested for?
Originally, it got sent to our state police lab here in Massachusetts to test for all the normal things that we screen every possible overdose patient for. So it got tested for many things there. And then I asked specifically for it to be sent to NMS to test for ethylene glycol.
Okay. So let's start with the original panel that was done by the Massachusetts State Police. Was there anything in that testing that you noted as part of your autopsy?
Yes.
Okay, what was that?
That was positive for something called benzoylecgonine, which is a metabolite of cocaine.
Okay. So there was some cocaine metabolites in Mr. Fowler's blood?
Yes.
All right. Anything else in that? This is essentially a toxicology test, is that fair?
Yes.
Okay. Anything else in that toxicology report that you noted or was important to you?
No.
Okay. There was no evidence of Percocet use by Mr. Fowler, is that fair to say?
Percocet is acetaminophen, Tylenol, mixed with oxycodone, and both of those were completely negative.
Now, with respect to the additional testing that was done at NMS labs, what was NMS testing for you?
I believe in this case they were only testing for ethylene glycol.
Okay. And you received the report back from NMS with their findings as to the presence of ethylene glycol in Mr. Fowler's blood, correct?
Yes.
Okay. What were the results of the testing?
It was present in this sample. The concentration was 52 nanograms per milligrams per deciliter.
All right.
Sorry. Nanograms per deciliter.
All right. Once you got that result back, and then in connection with the tubular necrosis that you described for us, the calcium oxalate crystals in the kidney, the brain swelling and brain stem hemorrhage, and then in conjunction with all of the information that you had from Mr. Fowler's medical records, were you able to determine his cause of death to a reasonable degree of professional certainty?
Yes.
And what was your conclusion, sir?
That it was ethylene glycol poisoning.
Okay. So how does ethylene glycol kill somebody?
Sure. This is tough. Let me just correct. Since I said nanograms per deciliter, it was milligrams per deciliter.
Okay.
Just for the record.
All right, thank you.
How ethylene glycol kills someone, it's a rather prolonged process. After ingestion, it usually takes a few minutes, sometimes up to 30 minutes to show any symptoms, but there are generally 3 groups of symptoms that you see at different times. The first group generally happens in the first 12 hours, and you see mainly neurologic symptoms. So it acts a lot like ethanol intoxication. Ethanol is just the alcohol that people drink at bars. So you exhibit similar behaviors, loss of coordination, slurring of speech, confusion. Depending on the amount, you can also have vomiting, abdominal pain. You can even die during this period and have seizures.
But not in that
Then
order.
usually after 12 hours post-ingestion, you start having more cardiovascular symptoms, and those include high blood pressure, fast heartbeat. You can have what's called Kussmaul respirations. That's just breathing very quickly and very deeply. And you do that because what you also have during this period, even sometimes earlier, is metabolic acidosis. That's when your blood becomes more acidic than it should be. And your body wants to correct that by breathing deeply and quickly. So that's why you have those breathing changes. You can also, during this time, die from cardiac arrhythmias or from congestive heart failure. And then the later period, usually after a day or two, you can have renal failure, kidney failure. And the reason this happens is, I should back up and say, ethylene glycol itself is not necessarily toxic when it's in your bloodstream. It gets changed by an enzyme in the liver into first glycolic acid, which is what causes the metabolic acidosis. And that is toxic to many different organs. And then the glycolic acid can or is eventually changed to oxalic acid. Oxalic acid is what damages the kidneys. It combines with the calcium that's normally in your bloodstream into the calcium oxalate crystals that we just saw. So this decreases the amount of calcium in your bloodstream, which causes your muscles to have spasms. So during this portion, you can also have muscle jerking and spasms, almost like seizures, but not of your brain. But those crystals that we saw in the kidneys are what kills the kidney cells. It blocks some of the tubules, it damages them. The acid itself might also damage the cells. So that is the final thing, is the renal failure.
That's terrible.
The renal failure is the renal failure, the calcium oxalate crystals, the tubular necrosis, that would be essentially stage 3 of the 3 phases that you just talked to us about?
Yes, and you can die during any of these phases. Generally, you die from multi-organ failure, but these are the organs that are affected during those certain times.
All right. Now, which of the, I'm going to use the term stage 1, stage 2, and stage 3. I know that they overlap, and I know that they're not, sometimes as discrete as we're trying to make them sound here. But what stage 1 symptoms did Mr. Fowler show that you were aware of?
Action, Judge.
Overruled. He may have it based on his review, and you've considered all the medical records from the 3 hospitals you indicated. Is that correct?
Yes.
All right, you may answer.
Even as early as the EMS report, who arrived to his house, mentioned that he was that he was confused, that he was not exhibiting good coordination. In the first ER, Anna Jakes, he had dry mucous membranes, which shows dehydration, which is one of the other things that I didn't mention. He had altered mental status, which you would expect. He had abdominal pain, I believe nausea, though I'm not totally sure.
Nausea being some sort of vomiting.
Or he was just wincing when they pushed on his abdomen. He seemed dizzy, drunk, like symptoms.
Okay. And slurred speech or inability to speak, could that be a stage 1 symptom as well?
Yes.
All right. Now, into the stage 2 symptoms, which of the stage 2 symptoms that you just described for us did Mr. Fowler show?
I believe in the first hospitalization, the first day that he was at Anna Jake's, he also had the fast, deep breathing that we described.
That's the Kuzmal breathing that you just described?
Yes. And that was the hospital where they first saw metabolic acidosis.
Muscle spasms were present, is that fair?
Either that hospital or the next one, they described jerking movements.
Okay.
I think the second hospital.
Second hospital?
No,
so that would have been Mount Auburn?
Yes.
Okay. Now, the stage 3 symptoms that you described for us, which ones of those did Mr. Fowler display?
If you're talking about the renal failure symptoms, it's kind of complicated because he showed signs of early renal failure at the first hospital. And then I believe before he even went to the final hospital, his metabolic acidosis had cleared up, but was still showing signs of kidney failure.
Okay.
So he probably had kidney failure or some amount of kidney failure at all 3 hospitals.
All right. Now, you mentioned so sometimes, as you said, some of those symptoms, they get put in the stage 3, but in Mr. Fowler's case, they might have actually showed up in stage 1 or stage 2. So it's not sort of one stage doesn't end and the next stage doesn't immediately begin. There's overlap and it depends on the course of everybody's different progress with the disease or with the illness.
It also depends on how many ingestions there were, what times those were. So
multiple ingestions can change the timeline of symptoms.
Yes.
Is that because ethylene glycol would then be hitting the bloodstream and hitting the organs at different points throughout that timeline?
Yes.
Now you mentioned, sir, multi-organ failure. What is multi-organ failure?
So that just means there's more than one organ involved in the death. And technically, probably most deaths are multi-organ failure.
I'm sorry, go ahead.
At some point, but we use the term when they're hospitalized, still alive, but you can see multiple organs failing.
Did Mr. Fowler show those signs of multiple organ failure?
Yes.
Which organs of Mr. Fowler's were failing or had failed during the course of his hospitalization?
Well, his kidneys showed signs of failing early on. At the final hospitalization at Beth Israel, he lost pupillary reaction. That's when they shine a light in your eye. The pupils are supposed to get smaller. When they don't, that's a sign of brain damage. So his brain failed at the final hospital.
Okay. And was that, obviously, when your brain fails, is that ultimately what killed Mr. Fowler?
He was on a ventilator, so once you have brain death, the doctors do brain death testing to show that you have no chance of recovering, and then your body is still being kept alive by the ventilator and by your heart if it's still beating. But once you remove that, then that is when your body also dies.
And so all of those symptoms that you just described for us were the result of the ethylene glycol poisoning and the body metabolizing that ethylene glycol into the other various substances that you mentioned for us?
Yes.
Okay. With respect to that metabolization, at some point during after exposure to ethylene glycol, the body essentially metabolizes all of the ethylene glycol, and now you're only left with these byproducts. Is that fair?
It can, depending on whether your kidneys are still functioning. You can metabolize it all. In this case, he also was treated with something called fomepizole and also with hemodialysis, which is where you filter the blood outside of the body when your kidneys are not working. So that probably would have removed a lot of the ethylene glycol if there was any left.
Now, just finally, doctor, did the cocaine that was in his system appear to have any effect on his cause of death?
No, the mechanisms by which cocaine does cause death were not present here.
Okay. So, your opinion, to a reasonable degree of medical certainty, that what killed Mr. Fowler is ethylene glycol poisoning, is that correct?
Yes.
Thank you. Nothing further, Judge.
All right. Thank you. Mr. Norkunis.
Thank you. Cocaine injection, doctor. Cocaine use by itself accelerates the heart rate, right?
Yes.
And this gentleman had heart problems, right?
He did have heart
Stick by
You
the
indicated
microphone.
He had some sort of blockage in his arteries as well, correct?
Yes.
So cocaine use was a substantial risk to him with all those comorbidities already within him, right?
Yes.
Now, you began the presentation by indicating that, question from Judy, that you've had one case, correct, previous to this, dealing with ethylene glycol? Or was it the only case?
This is the only case.
Okay. And then you decided, you chose to go out and do some reading about ethylene glycol, correct?
Yes, but also I had read about it before this.
Okay. And were you also aware of a statute dealing with ethylene glycol in Massachusetts?
The one about putting bittering agent into it? Yes.
So Massachusetts legislature, in their wisdom, we assume researched the matter, and because of improper use of ethylene glycol, put a product into it in motor vehicle products in Massachusetts, correct?
Correct.
And the legislature determined that the Beatrix was one of the most bitter substances known to mankind, right?
Yes, that's denatonium.
It's big name, right?
Right.
I can't pronounce, but it's
Benzoate.
It's known as Beatrix, correct?
Right. I think that's its brand name.
Now, when you, just as a side, when you sent the blood out to NMS, was there any interest in finding out whether there was Beatrix within it?
I think when I sent it,
Right.
no. I discussed it with the detective later.
All right, so the Trooper Williams,
Yes, I think it was him.
whether you should test for Beatrix?
We discussed, he asked a question about whether I knew if you could test for it.
And at that point in time, it would be fair to say you had never had the need to do it, so you didn't know whether they could or they couldn't, right?
Well, the medical examiner is mainly in charge of determining the cause of death. So I believe I told him that we can't do it, but maybe some lab somewhere might, and I don't know.
Okay. Now, there was some brief discussion with you about tasting or whatever else, right? Whether a person could taste something. Your field of medicine is dealing with people that are dead, right?
Correct.
You can't determine whether they can taste or they can't taste, right?
From doing an autopsy, no.
Now, in this particular case, when you did the external exam, You indicated you didn't find anything of substance indicating there were head injuries, body injury, external body injuries that you could determine, correct?
Nothing that would have contributed to his death, no.
But nothing that would have needed or required immediate medical attention. Would that also be fair to say?
No signs of anything that would, no.
Now, in relation to this particular case, you had talked about the calcium oxalate crystals, correct?
Yes.
And other causes of forming those types of crystals can be a high sugar intake, right?
I'm not totally sure that that could cause that, but there are other things that can
People
cause
with diabetes sometimes have a higher number of calcium oxalate crystals. Are you aware of that? Or do you have any knowledge about that?
I know that you can have oxalosis or oxaluria from other things, yes.
Which would create the crystals in the kidneys, right?
Yes.
Now, is it fair to say that any of the people that you, the bodies that you look at, you don't open the kidneys unless there was a problem that you believed attributable to their death from the kidneys?
Any case that we autopsy, we look at the kidneys.
You look at everything?
Yes.
Pull it all out, okay. And many times you find oxalate crystals within the kidneys, correct?
I've never seen them before this case, in the kidneys.
Now, in this particular case, you had discussed with Mr. Filio what's generally recognized as the 3 stages of someone who has ingested ethylene glycol, correct?
Yes.
And the first stage is generally something you would equate to being, you would look at the person and say they might be intoxicated from liquor, right? Ethanol itself, right?
Sure.
And the timeline for that can be 30 minutes, right? To 12 hours, right?
Right.
That means there's a variant that's undeterminable in advance or even afterwards, depending upon the individual person, right?
Yes.
And in this particular case, did you become aware that Mr. Fowler, the deceased, was texting up until 5:30 in the morning on an iPhone with a consistent message and using and having the dexterity to manipulate that phone and use it all the way up through 5:30? Did you become aware of that?
I don't think I knew that, no.
And that would be something that most people who are inebriated and losing their dexterity and their physical abilities won't have fingers on a small screen that will be able to type a consistent message, right?
Depending on the severity.
The level of intoxication, right?
That could be true, yeah.
And at 7, assuming for me, at 7 o'clock in the morning, Mr. Fowler is sufficiently impaired that he can't stand up. That would show at some point in time that the first stage had come on within half an hour of that time frame, right? Maybe?
No, I don't.
If the stages are correct, right?
I don't know.
You don't know
at
exactly
what
with him when it was
exact hour you would lose the ability to text.
Now, you get to look at his personal medical records, right?
Yes.
And then you get to look at the hospital records.
Yes.
And they said that he had polysubstance abuse, right?
Yes.
And generally, is it accepted in the literature that you have looked at in looking at ethylene toxalate that if you've talked about the medication and the dialysis can assist the person, right?
Yes.
And if the person is receiving treatment, did you learn within the first 4 hours, particularly the medication, that they can be saved?
the earlier you receive that the medication and dialysis, the better chance you have, yes.
And for those people that might not have the medications, you could also give them liquor, right, to change the ethanol to methanol, right, within the body?
I believe before the 1980s, that was the original antidote. And
it would still work to some degree, correct?
It works nearly just as well, I think, as fomepizole.
Now, in looking at the records from Anna Jake's hospital, he was taken there and arrived there at 9 o'clock in the morning, right?
Yes, I think like a minute or two before that.
I can show you that, but I'll suggest that too.
Right.
And he doesn't get to Mount Auburn until 9 o'clock at night.
Yes, later that evening.
And Anna Jakes is unable to recognize what his need for treatment is. It's fair to say from the records, correct?
They were ruling out a lot of causes, and I think they had a pretty good idea by the end.
But did nothing for it, correct?
They did a lot of things. They intubated him. They
never did
started the diagnosis.
No, they didn't have that diagnosis, right, of ethylene
But they
glycol poisoning.
did not do fomepizole and hemodialysis until the second hospital.
It was either one of those, right?
Right.
They didn't give him liquor off the shelf. So in essence, in terms of what his final resolution was, they didn't treat it, correct?
No.
And so by the time he left there, more than 12 hours likely had passed from any ingestion, correct?
Yes.
And at that point in time, then, he perhaps had already gone beyond stage 2, correct?
Yes, possibly he was at stage 2 already in the first hospital.
Now, and then they used dialysis upon him, you've indicated that, to take out his, the ethylene glycol that he has in his system, is that correct?
Yes.
Now, when you looked at the medical records, was that also inclusive of looking at the records from Beth Israel Hospital?
Yes.
And did you look at the record from on the 13th of November at 6:42 a.m. by Dr. Sin, S-Y-N-N?
I looked at all of them at some point.
Okay. And were you aware of the team that he had looking at him? And his determination was that the history from Mount Auburn could be consistent with ethylene glycol ingestion. However, the story is a bit unusual.
Yes.
Remember reading that?
Yes.
And this again was the team from Beth Israel, correct?
Correct.
They had spent more than 65 minutes with him as they set out in their report, correct?
Yes.
Theoretically, and they say at that point in time, there was also no clear history of any ingestions in this particular case. And his levels are normal with them. And they were unclear as to whether it was actually ethylene glycol, correct, at that time?
I'm not. Yeah, let me see it.
May I approach it?
Yes, you may.
Time is up here.
Yeah, so no clear history of ingestion just means that nobody told them that there was any ingestion. When they say that it's a bit unusual, they're talking about the fact that the osmolar gap was not high at the first hospital, which normally the osmolar gap is high at the beginning and gets smaller. And
Let me pause for a moment. That would be in the first 12 to 15 hours, correct? So he didn't have that
Right.
within the first 12 to 15 hours. And that therefore makes it somewhat of an unusual situation, right?
I do think there was a osmolar gap at the second hospital, but yes, it's not exactly the 3 stages, which I already said don't always follow that exact timeline.
Now, at some point in time in the Beth Israel records, did they believe that he died of a stroke?
If by stroke you mean brain swelling with brainstem death, then yes, the stroke team was called because of his pupillary non-reaction. The stroke team gets called to come and see what's wrong. And I think at the prior hospital, Mount Auburn, they had already done head imaging that showed swelling brain. So I think they knew that that was already occurring, and that's why they transferred him, so that he could have electroencephalogram monitoring at the other hospital, at Beth Israel.
So at Mount Auburn, he gets dialysis, right?
Yes.
And he also gets that
electroencephalogram
that you mentioned. I think that was also used for him.
Yes, fomepizole.
Would you just spell that? I've heard it many times, and I don't know if it begins with an F or a H. I can't quite
It's
hear it.
F. I hope I know how to spell it. FOMEPIZOLE.
That's close enough. I
I
now
hope.
have a sense of what you're saying. That's all I want.
Okay.
Brainwave study. Right.
Now, when you sent out the blood sample to NMS and they came back with 52 milligrams per deciliter, that equals about 26 grams. Would that be the equivalent when you're chasing the metric system into grams?
Grams is the metric system. So milligram just means 1,000th of a gram.
Grams.
So no, it would be 0.052 grams.
Grams is the metric system, sir.
Per deciliter.
Per deciliter.
Right.
That was funny. It's the ounces that'll get you. Everybody in Europe is laughing right now.
Yes, you may.
Everyone in every other country other than the U.S. is laughing. Grams is the metric system. Apparently not covered in law school, Judge. Thank you for that one. Brings us to 740. Well, I heard one in the background. That is 748 now. It's funny here in the United States, but it's hilarious anywhere else. I've been in touch with Trial TV Live. They'll be back up tomorrow. YouTube did YouTube things. Oh, man. During the Kelsey Fitzsimmons closing.
You did not make any attempt to try and do a timeline based upon the
A pew was waved around, and YouTube gave them a violation strike.
When Mr. Fowler might have consumed any ethylene glycol.
I don't think you can be very accurate just based on the lab values and hospital records. The fact that he was already exhibiting renal failure may argue that it was many hours earlier, but I can't be sure.
It would be also a fair statement that his comorbidities as to any effect upon either acceleration or not acceleration of ethylene glycol was not something you made a determination.
His comorbid
is undergoing
right. It's hard to determine if someone has a very, very bad heart, whether they may have survived. In this case, I don't think so. But in a case where the poisoning maybe could have been saved if they hadn't had heart disease, then I sometimes consider that. But in this case, I think he had so much that his kidneys would have failed no matter what, and his brain was swelling either from the toxic effect of the acids themselves or from lack of oxygen.
And it's likely by the time he left Anna Jake's hospital, there was nothing any further medical care could do to save him, right?
I'm not totally sure about that.
Whatsoever. And the ethylene glycol is metabolizing and moving at whatever speed it moves through the body, right? And he's thoroughly into stage 2 at that point in time, right?
Given the fact that he got the known treatment at Mount Auburn Hospital, the second hospital,
For the timeline.
and then still died, it's possible that he was on that trajectory after he left Anna Jake's, and nobody could have saved him.
Thank you. Nothing further, Judge.
Mr. Camellia?
So just fair to say that getting him to the hospital sooner would have improved his chance of surviving.
Yes, the sooner after ingestion, the better.
The longer you delay, the longer someone delays, for instance, in calling 911, the more likely the person is to die from ethylene glycol poisoning.
Yes, also the diagnostic process sometimes takes a long time. So if you have no idea what's causing something, it's harder to know that you need to treat it this certain way.
Thank you. Nothing further, Judge.
But that's still within this, the first, say, 4 hours, right? If you get to them within the first 4 hours, you can treat them somehow, even if they had to give them liquor at Anna Jake's hospital, right? If they recognize what the issues were.
Liquor
The sooner the better. So I'm not sure there's a certain number of hours where it matters.
Liquor buys time. It doesn't stop the damage.
Thank you, Judge.
Thank you very much, Doctor. You may step down.
Well, I think we get a little bit of notebook reading in this morning. We should get that in just a moment.
Your Honor, as we discussed yesterday, I have a couple of things that I'm going to read to the jury. Request permission.
a sidebar, Judge?
Yes.
So they're going to go sidebar. That was the last witness for the prosecution. And we're going to hear a couple little notes from these notebooks the defense does not like. They're going to put one more fight up to keep these out. They're going to come in, I'm pretty sure. I doubt anything's going to change right here. And while we wait for them to discuss this at sidebar, which I can sort of speed up, I can make them talk fast. Hold please. So let this sidebar, which actually turns into a fairly lengthy little exchange. There we go. Cut a couple minutes off that one. Let's go back and see what the outcome is here. Give them a couple seconds. Wait for it.
I think it's the last step before the Commonwealth arrests. I'm going to permit Mr. Camilio to read a few passages from
They're coming in.
One or two exhibits that are already in evidence. These are these from a single notebook or from two different notebooks?
Two different notebooks, Judge.
All right. So you'll recall that notebooks that were seized in a search of 108 Central Ave are before you in evidence. Normally, we would have had Mr. Camilio, Trooper Williams, simply read these excerpts. It's for you to determine what they mean and what meaning you would attach to any particular excerpt that is read. Trooper Williams wouldn't have been permitted to give his own interpretation. And so to save time, that wasn't done with him on the stand. You recall we were trying to finish his testimony. So I'm now going to permit Mr. Camilio to basically read himself what he would have had Trooper Williams to read. Mr. Scully, on behalf of the defense, may or may not choose to read some other excerpts that he would have had Trooper Williams read on cross-examination. If he wishes to, perhaps he won't. Bear in mind, however, that you have these exhibits in front of you. It's for you to consider the content of all these exhibits, for you to give what weight and significance and interpretation to not only the passages that Mr. Camillo may choose to read or Mr. Scully, but for the rest of the notebook entries as you see fit to give them. Mr. Camillo is simply reading these to you. He's not going to do this in dramatic fashion. This isn't a dramatic reading. He's simply going to read the words to you. And if he was intending to do otherwise, this is my way of telling him this isn't a dramatic reading.
Flat voice.
And so bear in mind, he's really not a witness. He's simply an advocate who's reading this exhibit to you. The defense has copies of the exhibits. If they think he gets any of the words wrong, they will let me know. And again, if Mr. Scully wishes to read something after that, he may not. But if he does, you will then hear him read a passage or two. Go ahead, Mr.
Thank you, Judge. I will strive for no drama whatsoever.
All right.
The first excerpt is from the red notebook, which has been previously marked as Exhibit 19. It reads at the top of the page, "I want the man you were, not the one you became, since letting your moral compass go, your guard down. Are you such a player now?" And then there's two lines that are crossed out, that only your feelings matter, screw mine. And then on the side of the page is written, "The evil seeped in and corrupted you beyond recognition."
Okay.
One of the other excerpts is now from Exhibit 18, and that is the purple notebook. "I hate being alone. I hate you for all the lies, exclamation point. You don't love me, exclamation point. This is not love with not underlined." And then on the next page, at the end of a longer entry, is written, "And I know what cunt face meant by challenge, in quotes. Have fun with the shithead AIDS victim she brings home. I will never be in competition with her. She'll lose every time in every way." Thank you, Judge.
You're welcome.
And with that, does the Commonwealth rest?
Your Honor, the Commonwealth rests.
All right. Jurors, I'm going to excuse you very briefly while I chat with counsel, and then we will proceed with the defense case, or at least the beginning of the defense case.
All right.
You need to do a dramatic reading of those ones. We can't. We thought we would be able to, but then it ended with a
Jurors, I
bang.
think we'll treat this as the morning recess because I think
20 minutes.
that we'll be able to go through whatever defense witnesses we have and let you go after that. Thank you.
Half day. Commonwealth rests. Now we get a motion for judgment of acquittal or directed verdict or however they want to call it here. If the judge survives, it's coughing up a lung.
Judge, Mr. Scully will argue for us on the motion for required findings.
Yes.
Motion for required findings. Go to the mic, please, sir.
Yeah, you do it.
I knew it.
And approach clerk to file.
Yes, you may. Mr. Scully, I just realized I didn't turn to you after Mr. Camillo finished and asked, did you want to read any excerpts, which I will still permit you to do if you wish, but I should have asked you formally, and I just forgot.
That's okay, Judge. I was trying to figure out what, if any, excerpts I might read. Couldn't figure them out, so I was going to pass on.
Okay, that's right. I apologize, still, for having neglected to formally ask you. Mr. Scully, I will hear you.
Well, I don't think there's much to add. I know the court has been following along very closely, taking its notes. I think the case has come in the way primarily the parties predicted that it would come in their opening statements, and the prosecution has, introduced a circumstantial case which I feel, which I would submit to the court.
Judge is now in stage 2.
Anything beyond a reasonable doubt. We don't know what happened to Leroy Fowler here. There are multiple possibilities. I would suggest there are several that don't outweigh each other. And I would ask that if the court makes a ruling, that it does so in writing on this rather than,
In writing?
Directly, and I would waive further argument.
All right.
No.
I'm not going to make a ruling in writing. I can almost never recall having made a ruling on a directed verdict motion in writing, even when I've granted motions in whole or in part. I am denying the motion. It's construing the evidence in the light most favorable to the Commonwealth, as I'm required to do, and drawing all inferences, reasonable inferences, in favor of the Commonwealth. I find that the jury could determine beyond a reasonable doubt that the Commonwealth has proved all of the elements of the charge of murder in the first degree by both theories, that being deliberate premeditation and extreme atrocity or cruelty. I don't really think I need to say more beyond that, but that sufficient evidence has been presented by which the jury could find that there was a deliberate intention on Ms. Church's part to poison Mr. Fowler with some ethylene glycol substance, and that the manner of doing so ended up being a killing with extreme atrocity or cruelty because of the time frame, the various stages that Mr. Fowler went through, basically what a prolonged death this ended up being. So I deny the motion for directed verdict. I preserve Ms. Church's rights with respect to that ruling, and I'll say nothing further on that. The defense is presenting what witness or witnesses today?
Judge, we just have one witness today. It's Michael Kahn.
Michael Kahn, all right.
From MCR Labs.
Okay. Then before we give you all the morning recess, and then we'll hear Mr. Kahn and we'll recess for the day, let me just take up something I neglected to take up the other day, which was that Exhibit N. This was a thumb drive that contains a video, which I viewed. I'm sorry, it was Exhibit P.
Was
right?
the thumb drive? Yes.
Yes, Exhibit P, okay. Which contains a video set to music. There were, by my viewing, 14 photographs and 3 either videos or moving photographs of Ms. Church and Mr. Fowler together in various locations. A few photographs, their dog is with them. From the way that Ms. Church and Mr. Fowler are dressed in the various images, it appears to me that, and there are 17 separate photographs or moving photos or videos, it appears that they were taken on 6 different occasions, as far as I can tell. The video is 42 seconds in length. Mr. Scully, what is the theory of admissibility on this? And,
Please know on the
and
music.
where did it come from?
So this, there was testimony about this. I cross-examined Trooper Williams about when he searched the phone, and he was, through the prosecution, introducing various excerpts and photographs and the like that he found on the phone.
Right, and he didn't see the video because he didn't think that a video of this sort, he hadn't seen it, was within the scope of the search warrant. So
I don't think he testified to that, Judge. I think he was.
He actually said that. He said, "I don't believe I saw the video. It wasn't, I couldn't search for just videos like that."
I think he saw the video and was familiar with it and overlooked it. That's my sense, Judge. I don't.
Your sense from what, Mr. Scully?
That's
from
my
what he said on the
testimony.
stand?
Right. In other words, the limitations to the search warrant that was for text messages and data and the like is not the same limitations as for photo and videos. They obtained a different search warrant for photos and videos, is my recollection, and I'm not aware of any restrictions to them. He didn't have a clear memory, is my memory of his testimony when I tried to cross-examine him of the video. It wasn't, so my point is this goes to the police bias in the investigation, that they are willfully overlooking evidence that showed the positive relationship, the loving relationship that did exist throughout the years between Judy and Leroy. and they're cherry picking things from, years past, 2000, at least 18, 19, 20, 21, from various sources on the phone, these little constellation points, and now trying to put them together on that evidence table up there, while completely turning a willful blind eye to some basic information that there was that I think the title of that video was Together Through the Years, so it seemed appropriate because it shows a span of time and the loving relationship in a softer light than the one than just the text messages, which are more of an explicit nature that also came in through Trooper Williams.
All right. I understand the theory. I'm just looking back at my notes, what I took down in response to what he said, and what I had him saying. This isn't a direct quote, but it was my understanding of what he said, was that he wasn't permitted to view it, and he couldn't say that it came off the phone. So if it's a Bowden theory that this is evidence that they overlooked of this loving relationship, I don't think there's an evidentiary foundation for it. But what's the Commonwealth's position with respect to this? You objected, but I didn't ask.
I do, Judge. This is my understanding, based on what I've seen on that disc, that I don't know how much the court knows about iPhones, but iPhones have some capabilities to sort of create these things just sort of on their own. They it's a way to show you your memories.
I'm not that much of a Luddite.
No, I didn't mean that, but this is something I didn't know.
Enjoy them. My phone creates them, and all of a sudden I'm looking at the stroll down memory lane. Right, so yes, I enjoy them.
Maybe I'm more of a Luddite than you. I really depend on Mr. Asnick for my technology education in this case, but and Trooper Williams for that matter. But this is I don't know, Apple creating this thing for you to sell you and keep you invested in the Apple ecosystem. I don't think that the fact that it wasn't created by Miss Church, so it doesn't show her view of the relationship. It doesn't go to her state of mind. It goes to the things that Apple has cherry picked out of her phone.
Well, I don't know. It may have been Apple. It may have been Miss Church. I don't know. There's no evidentiary basis to tell me one way or another.
That's fair. And my memory of the testimony is the same as yours. That Trooper Williams said, or Sergeant Williams, I keep demoting him. Sergeant Williams said that no, he didn't have a recollection of having seen that. The search warrant itself, Judge, was the second one that was done in this case, and the specific videos that he was allowed to look for were videos depicting Powerade, soda beverages, coffee, milkshake, or toxic chemicals. Otherwise, he was limited to that November 11th, 2022 date.
Well, that's what my notes reflect. He was saying when he said he didn't believe he saw it because he thought it wasn't within the scope of the videos that he could search for.
I do think there is some danger here that the way we've been discussing this, because there was never sort of there was a general motion to suppress these search warrants, and obviously denied, but some of the issues of plain view for the trooper were never that was never raised with respect to things that were found. So, I just don't want there to be a, sort of a question on appeal, if it ever gets that far, that this is sort of a live issue based on that motion to suppress. That was not litigated in that sense. So, I don't see that as a live issue. But I think what is important for the admissibility of these documents is right here is that, as the court said, there's no evidence that Trooper Williams ever saw it, so he couldn't have considered it for purposes of Bowden, and there's no evidentiary foundation for saying how it got on the phone, who made it, was it technology that did it without anyone knowing it was there? Was it Miss Church? I stand by my objection.
I'm sustaining the objection for the reasons I've said. There is no time frame on the on the video or the photos, but that wouldn't be necessarily an impediment. to its admissibility because, for example, if Ms. Church were testifying, just as Mr. Scully points out, the Commonwealth has cherry-picked certain texts and whatnot from going back to 2019 to try to portray the relationship going back some period of time. I would certainly allow Ms. Church to testify that this was a loving relationship and talk about, these photos reflecting that. Whether it was back in 2019 or 2020, 21, I would certainly permit her to do that. I think she was able to express that view fairly articulately and forcefully a number of times in that recorded interview I saw, where she stated over and over again that she loved Mr. Fowler. But in any event, and I'm not certainly suggesting that Ms. Church needs to testify in order to authenticate this video and admit it, but I would have permitted that because she would be the proper person to do that and explain, because Trooper Williams really couldn't and didn't. So that's my ruling with respect to that.
I have another grounds I'd like to raise for the record, Judge, which is a due process grounds, which is that we know this phone was taken from Ms. Church. We know this video was on this phone. There's no dispute. The Commonwealth is, painting a very one-sided, as is its right, and limited view of a relationship. In our view, taking it out of context in order to serve the purposes of the prosecution. The defense has a right to put in evidence to broaden the scope of the jury's view. That's our right to put on a defense and to show that there's much more to the relationship. This particular video, which is short in nature and was on her phone, was there in plain view for the police to look at through the search warrant or not. You've made a ruling relative to Bowden. But now I would move to introduce this pursuant to our due process rights to put a defense on, and that this piece of evidence is a fair counterbalance to the misleading picture that the prosecution has tried to show throughout this case, including by putting together reading in journal entries from unknown times about their relationship, phone notes from unknown times about their relationships, and various photographs and other evidence, text messages and the like, and statements from other witnesses. So this is our due process moment to put that one piece of evidence in, or this particular piece of evidence in, to help counterbalance that, and to corroborate also what Judy Church did tell to the police about the loving and good nature of their relationship. She did testify, or not testify, but she did tell the police in her interview that she loved this man, that he was his world, and that she would not harm him and did not harm him, right? And this video is a crucial piece of evidence to show that that's just not a statement of self-serving interest. Here's a short video set to music on her phone that really captures, in a unique way, a long relationship that went on for many, many years.
I understand the argument. I don't think this fits within the parameters of the very narrow due process constitutional hearsay exception, and it is a hearsay exception. It's generally not just a broader due process exception, but there's a few components to it, and one is the evidence has to be fundamental to the defense and not available through any other source. The case law under Drayton is the case, but the case law under that particular exception even makes clear that if, for example, the evidence sought to be introduced pursuant to the exception is available if the defendant testifies, that's a factor cuts against its admission under the due process exception. I don't find this evidence to be fundamental in any manner. The fact that there would be some loving photographs of Miss Church and Mr. Fowler together, who spent at least 8 years as a couple, is hardly surprising, and it's really neither here nor there as to what the exact nature of their relationship was on November 11th, 2022. It might be helpful to the defense, but fundamental it is not, in my view. And so I don't find that exception applies. So I stand by my ruling and I preserve your rights.
And just to clarify for the record,
so will she take the stand?
I don't view this as a hearsay issue because I don't think that the music is being submitted for the truth of the matter or the photos or words on the song.
It's not, and I don't view it as a hearsay,
Right.
but the due process right that you're noting is generally one that's been characterized as an exception to the hearsay rule. That's generally why it's coming in.
I think of it in this terms. We have the right to call witnesses pursuant to the due process clause.
Yeah.
We have the right to introduce exhibits pursuant to that clause. In my view, we have the right to introduce this exhibit under that, broad and most powerful right. We don't have this without due process. So that's where I'm looking at it. And I don't think hearsay is there because we're not introducing this to show the truth of any of the words in the songs.
I agree. It's not a hearsay issue.
Right.
I agree with
It's a state of mind issue.
But I stand by my ruling for the reasons I've articulated.
Okay.
Now I'm going to let people have a break, and then we'll come back and hear the one defense witness who you're calling tomorrow.
So can we talk about that at sidebar in a few moments, Judge? I want to confer with Mr. Norkunis.
Well, I'll let you take the break, but before I let the jury go, I want to know exactly where things stand for
things are
tomorrow.
shifting.
I'm sorry?
What?
Things are
They're still
shifting. All right, so please, and by the way, I generally will have a colloquy with any defendant who's choosing not to testify. So it's your expectation at this point that Ms. Church will not be testifying?
I think that would be a decision that would be made between today and tomorrow.
Okay. If tomorrow morning you tell me that Ms. Church is not testifying, then probably before we bring the jury in, I will have that colloquy with her about her right to testify. But and if you tell me she's testifying, that's fine, and I'll forego it.
Right. I think that issue, actually, as we've been trading issues, is it going to be a Mr. Norkunis issue?
Okay, that's fine. All right. We'll take our morning break.
Court will rise.
Okay, we're going to skip through some of this break because we can. And let's see. Let's go here. Let's zip ahead. Get a little bit of a break here. We're now caught up. Couple things. My testing, I was able to get a little bit of orange. A little bit of orange by mixing colors, but you really have to dilute the Powerade quite a bit to get it to go away from red. That red's just a color; it just wants to hold. For example, let me show you this. Let's go on this desk here. You guys can see this. I'm going to try really hard not to spill. So we have our red Powerade. We're just trying to do color matching. That's it. The color we're seeking is probably like an orange like this, which is orange Powerade 0. We're trying to add yellow because yellow and red together are supposed to make orange. This is lemon Powerade. No toxic chemicals being used here at all. But as we go ahead and pour some here, we'll see if we can get a better color match. So 3/4 of a bottle of yellow added to the Powerade, and it's still quite red. Where's my other lid? It's still quite red. Let me show you. Here's an unopened can, a bottle of red Powerade, and here's our mixed one. Look at that. You can barely tell the difference. It's just starting to turn orange, which could indicate that the mixture of Powerade to other color fluid, like yellow fluid, if yellow fluid was used, was like a 3-to-1 ratio, or even a 4-to-1. Just for comparison, Rain-X is that color. So. All right. Do I have a spectrometer? I have a spectrometer. It's in a bin downstairs. It's not very scientific, but it would work. Maybe you need to pour the red into the yellow. Let's do that. I only have a little bit of yellow left. I'm going to try to get my kids to drink this, but I don't think they will because they saw me stop at the auto parts store. All right, a little bit of fruit punch into the lemon. Oh, I need to open the lemon one as well, or else it will spill everywhere. This is going to be so bad. Okay, here we go. Ooh. Just takes a tiny bit to go orange.
Call from
Legally Blonde, professional mixologist.
To accept, press 1.
Hello, Mixology. Are you there?
I am. Okay, so this is where my hairstylist education is going to come into big benefit here.
Okay.
You have to start with yellow and slowly add in red. Red pigment is way more powerful than the yellow pigment.
Yes.
So it's going to be harder to overcome that. So you have to start with yellow.
And that's what we just did. We added about.
I missed it.
Oh, it was very quick. We added just a tiny bit of red to the yellow, and it went orange very quickly.
There you go. Yeah.
So that actually.
Fun fact.
That actually.
Red molecules are usually bigger than other molecule colors.
Wow.
Yeah.
I didn't
Science,
know that.
bro.
Red is bigger. Now I've got these 4 bottles of mixed juice, various flavors plus a little bit here. I was impressed. First of all, what I learned from this.
Screeners.
What?
Sorry. Go on.
Yes.
You have what?
What I learned from this is that it actually favors the defense. If there's a bittering agent, if she like puts say for instance antifreeze in the bottle, and then adds a little bit of Gatorade or Powerade to make it turn orange, it probably is not going to be enough to cover up that bittering agent. It would have to depend on him not being able to taste it, or possibly cocaine use to get by that. Because this is going to taste like lemon. It's not going to take. Let me give it a try. Hang on.
Well, even if he wasn't actually
like
using cocaine at the time, doesn't cocaine like mess with your sense of taste because of the way it's ingested? Doesn't it cause like
the whole
smell,
nasal
taste
cavity
issues?
Thing? Yeah, I can imagine.
Right.
It would. I wouldn't know of myself, but
me either. Was he a smoker? Because I mean,
yes.
If he was a smoker, that'll that'll distort everything you taste.
Well,
that's it. That's really all I had.
Okay, so we figured it out. I thought that I could like drink half of red Powerade and then add yellow and get orange, but no, that red is super strong. To get
it's a really common
orange,
misconception. Yeah.
Just a tiny bit of red is all would be needed. So.
Yep, a little bit of red goes a long way.
All right, Legally Blonde. Thank you very much.
Sure,
I'm not going to ask where you got all your skills. No, you said.
Well, I was a hairstylist.
Oh, okay.
Yes.
And people want
I was also a bartender. But,
okay, that probably is where it came in more so than.
No, honestly, it was what I learned in hairstyling what I suspected as a bartender, but I learned the science behind why as a hairstylist.
Awesome. Well, thank you very much.
Thank you. Peace out, guys.
Bye.
Love you, chat fam.
See ya. Bye. A little bit of red goes a long way. Yes, that's interesting to me. It obviously it's not something that's binding on the facts of the case or anything, but I was curious what it would take to get a bright orange color in the bottle, and basically you have to start with yellow and add a tiny bit of red, and I would say it's such a tiny bit of red that you're only doing it to get the color match. You're not doing it to mask the flavor. There is not enough fruit punch in this bottle to mask the lemon flavor at all, but it gets the color right. All right. Let's see, where are we? We're all caught up. We're ready for the break to be over. Is Emmy done? The Emmy is done, yes, and we're going to be going to the defense first witness, and that's also the last witness for the day. So it's going to be a quick break, or a quick day today in court. The Reddit hair care science on Reddit agrees that the red molecules tend to be bigger. We're going to have Michael Kahn. Thank you for giving us the Kahn. What's that from? Kahn. I learned something today. Red is my favorite color. I think I missed the joke. A little bit of red goes a long way. I think I got it. I'm trying hard not to say. There are some terms that just don't work in court. They're words we just don't want to hear in court, and generally moist is one of them, and quickie is another. So it's from Star Trek. Yes. Star Trek Wrath of Khan.
Just use your words.
Maybe it was already lit. She told him it was orange flavor and didn't really taste it. I don't know how much of any substance was in his body. Yeah, we won't know. And this, let me just make my little gripe about this. As the defense is pounding on that issue of the bittering agent, it's something we can't know. We can't know if he tasted it and thought, oh, that's yucky, and he drank it anyway, and we can't know if he didn't taste it. All we do know is it's in his system. It's there. Whether or not it had a bittering agent does not matter because it got there. Am I the only one who sees it that way? Can we watch? No, Trial Fan. That would get us. That's actually what happened to Trial TV. They were showing the Kelsey Fitzsimmons closing, and the Commonwealth, or I think it was I don't know if it was prosecution or defense, brought out some of the evidence, the pew-pew, and demonstrated it by waving it around and racking it. And YouTube has some very sensitive, very strict rules about that. And Trial TV Live got hit with the community violation for that, which is a 24-hour live streaming ban. So they're going to be back again tomorrow. They're appealing it, obviously, because it was not a live, it was not them showing something live. It's tricky. It's tricky. But anyway, YouTube does what YouTube does, and we'll just leave it at that. We won't dig into that anything. Don't need to chat about it or anything else. But and it is applied unevenly. So big channels typically, and this is why I'm doing all these members only thing. Bigger channels get a person that manages the channel, and you can talk to a specific person, somebody who knows you, somebody who knows your channel. And when there's an issue like this, you can talk to someone. So bigger channels get that privilege, and they also tend to get more human interaction before a decision is made instead of robotic choice. Smaller channels just get zoinked, and and there's, it can happen easily. Smaller channels get pounded. That said, I'm extremely grateful for YouTube. I don't think they suck. They have made my career possible, and trying to work with their rules, and sometimes work with them to change their rules. But a real life sent in person, yes. Murder Show, welcome very much. Welcome. Thank you for gifting a membership. Basically the rules are not applied evenly. But when you look at it from YouTube's standpoint, it would be very expensive and difficult for them to apply the rules evenly. And it's not just we're losing money issue. It would require a lot of personnel doing a lot of hands-on, time-intensive stuff. So I can see why YouTube does it. It's sort of a tough situation. How much more red can you add till the orange turns red? That's a great question. Let me find the... Okay, this is the... I'll go here. This is the pure red right here. This is pure. Let's take that over here. I've got so many bottles on my desk. I'm so full. I drank so much to make room for this. I'm like full of Powerade. Okay, so... Here we have our orange, which we added just a tiny bit of red, and here we're going to add a little bit more red to it.
This court is now back in session. You may be seated.
We're back on the record with case on trial, Your Honor. Jurors are lining up.
It's already getting close. Just if you do just a tiny bit is all you need. How does it taste, though? I can taste the fruit punch, but it's very sour, like lemony. It's a little bitter.
Mr. Scully or Mr. Norkunis, did you get a sense of what tomorrow looks like yet?
I would say that is going to be under discussion, Judge.
Okay. Is there at least one witness you know you're calling tomorrow?
I think so, yes. Still under discussion, but we have one that I don't think we're going to change our mind on for sure, Edmund Crouch. And then there's Dr. Lake. And so the same witnesses we've been mentioning to you. And then the issue of whether the defendant testifies, of course.
Okay.
So, but
And the Commonwealth's rebuttal, is that dependent on what the defense does?
Of course.
Yes.
Right.
Always.
I think that depends on today. This is...
No, it depends on Celeste Waring.
Yeah, so I don't think, I'll talk to the prosecutor and make a final decision. I don't think we're going to call Celeste Waring.
Okay.
Medical examiner testified that denatonium benzoate is the most bitter substance on earth. That came in. That seemed to be a source of, on direct exam, I think. That came in, and that seemed to be one of the issues with
No, it
Celeste
didn't come in
Waring.
on direct exam. I don't think Mr. Camillo elicited that. Mr. Norkunis did on cross.
I forget which one, but it's in. So
It isn't.
That's
I
what
already
they
said
needed.
that.
no longer one that we feel we need to address with a particular witness, and that was primarily Celeste Waring as a toxicologist to testify about the nature of that substance and educate the jury that way.
Okay, well, that's fine. So you don't believe you're calling Celeste Waring.
That's my current belief. I want to revisit that, but
Okay.
that's my current belief.
This is both.
And if that plays out, Mr. Camillo, you wouldn't be calling your rebuttal witness.
Unless somebody else says something
Okay.
that,
All right.
but that's the expectation.
All right.
Awesome.
Billy, good to go. Come right in. Good to go.
Yes, for anyone who's concerned, all the drink I have on my desk is Powerade. The only bottle of stuff you don't drink that is nearby is a sealed bottle of Rain-X,
Mr. Camillo, are you doing
which
the
is for
closing?
my wife's car.
Yes, Your Honor.
We're not mixing the two.
And Mr. Norkunis?
Yes.
All right, we're good.
Did not buy any antifreeze. No, we just shopped. We shopped for it and talked. I talked to the clerk about it and told her what I was doing. Like, I'm looking to buy some antifreeze to mix into Powerade, but just for the color match. That's it, and it would all be thrown away immediately. So I decided that it's just not safe enough. I've got kids in the house. I don't want to risk anything, so I didn't even buy
George,
anything.
that was a more leisurely break than I had anticipated. I hope people are hyper-caffeinated. The defense is going to call its first witness. Mr. Scully?
Thank you, Your Honor. Defense calls Michael Kahn.
The clerk actually thought it was pretty cool. She's like, "Oh, that's awesome." I'm like, "It's not. It's not awesome. It's not good at all."
Just walking up to my car.
You stand behind this blue line and face the court.
Sir, would you raise your right hand for me, please? Do you solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated.
Good morning.
Good morning.
Morning, sir.
Good morning.
Okay, so that microphone both projects your voice so that the jury and others can hear you clearly, and there's a recording system connected to that microphone, so best you can stay fairly close to that, okay?
Okay.
Pot meat
Can
kettle.
you please state your name and spell your last name for the record?
Sure. Michael Kahn, K-A-H-N.
And Mr. Khan, what do you do for work?
I'm a chemist.
And where are you currently a chemist?
I'm a chemist at MCR Labs.
Okay. I'm going to ask you to describe your educational experience, starting with high school.
Sure. I attended Brookline High School. I graduated in 2001. I then
Started with
attended
high
Mass
school.
Bay Community College for 2 years. I then attended Brandeis University, where I graduated with bachelor's degrees in physics and chemistry and a master's in chemistry. And then I attended a PhD program at Boston University, which I left after 3 years to join the private sector.
Okay. So you completed your master's degree spent a substantial time studying for your PhD, but didn't complete that process at the end, right?
Correct. Yes.
And when you got your master's degree, what year was that?
I went from Brandeis in 2006.
Okay. Was there another master's degree from BU?
Yes.
What were those in?
Chemistry.
Okay. Now, have you published any works related to your field?
In chemistry, yes, there was a platinum paper and then a separate crystallography paper for the crystal structure of THCA.
What is THCA?
Tetrahydrocannabinolic acid.
Weed.
Okay. Now, as far as your employment background, starting maybe at BU and moving forward, did you work at Boston University for a time?
I was a research fellow and a teaching fellow, so I taught chemistry and I taught chemistry classes and laboratories, and I did research there.
And do you remember the approximate years that was?
That was 2006 to 2009.
That was when you were in the PhD program?
Yes, concurrent.
Okay.
This
And
guy was
then after
popular
you
in college.
completed working at Boston University in 2009, did you took a job in the private sector?
Yes.
Where did you go to work? What was the name of the company you worked for?
It was Shiloh House Jewish Day School, elementary school.
And what did you do there?
Science and math teacher for grades 1 through 5.
How long were you
Was
an
not expecting
elementary science and math teacher for grades 1 through 5?
1 year.
1 year. And then did you go on to work somewhere else?
Yes.
Where next?
Next was Wolf Laboratories in Watertown. I was a scientist. Wolf Laboratories was a contract research organization, so I did work to develop drugs for pharmaceutical and biotech companies.
Okay. And how long did you stay at Wolf Laboratories?
Oh, approximately, 3 years, 2 to 3 years.
Okay. After working at Wolf Laboratories, what did you go on to do professionally?
I founded MCR Labs, an analytical testing laboratory.
That's where you work now.
Yes.
And can you tell the jury, please, give a common language type of explanation for what MCR Labs is and what they do?
Sure. MCR Labs is an analytical chemistry and microbiology laboratory, which means that we measure the amounts of contaminants and active ingredients. We specialize in natural products, and most specifically, we specialize in cannabis testing.
He's the weed guy.
And does the lab hold any accreditations?
Yes, the laboratory is ISO 17025 accredited.
What does that mean?
That means that we are regularly audited by an international organization for standardization. We document our processes, we follow them, we have training records for our employees, we keep records of everything that we do. It's a widely recognized standardization benchmark.
Okay.
Yeah.
Now, was there a time that you were contacted to work in this case?
Yes, it was in the spring of last year.
Okay, so spring of 2025?
Yes.
Fair to say that the defense team had reached out to you at some point?
Yes.
And that we had been connected by other professionals in your industry?
That is correct.
Okay. Now, did you agree to take on some work relative to this case?
Yes.
And what was the big picture work that you agreed to take on?
We agreed to develop and validate a method to measure the amount of denatonium benzoate in a sugary drink with ethylene glycol in it.
Okay.
And then to also measure the evidence sample that we received for the same substance.
Okay. And the evidence sample that you received, did you come to learn that that was an evidence sample that was taken from a certain Powerade bottle relative to this case?
Yes.
Okay. Now, when you prior to doing this work in this case regarding denatonium benzoate, had you ever worked or had experience working with denatonium benzoate in other circumstances?
Yes, I have.
Okay, and briefly, can you tell the jury what it was, that experience?
At my prior laboratory at which I worked, at Wolf Laboratories, when I developed a drug, you also need to develop a placebo. So a placebo is something that doesn't have the active ingredient of the drug, but is made to look, feel, taste like the drug. And denatonium benzoate was used to make the placebo as bitter as the drug.
Okay. And what is, based on your experience in that case and your experience as a chemist, what is denatonium benzoate?
Denatonium benzoate is, from my experience, one of the most bitter substances known. It's extremely bitter.
Like
it's used as a taste aversion substance to make, which means that it is used to prevent people from ingesting whatever it's put into.
Okay, and is there a commercial name that denatonium benzoate is commonly sold under?
Yes, there are several, but the most common that I've heard of is Bittrex.
Bittrex.
Yep.
So similar to Tylenol, for example, is a commercial name, and there's a medication that's underneath it, right?
Correct.
So Bittrex would be a widely common name. Denatonium benzoate is the ingredient primarily in it.
Correct.
Okay. When you started to do the work, in this case, to do the testing you just described, to see if denatonium benzoate existed and to measure it in the sample that came from the Powerade, did you divide that work into basically two different phases?
Yes, depending on how we characterize them. Yes.
And what generally was phase one?
Phase one was developing the method and then validating the method, which in layman's terms means that we made sure that we can measure denatonium benzoate in a sugary sports drink type matrix with ethylene glycol in it at various levels. And then the validation portion is to confirm that the method works as intended. And then phase two would be the measurement of the actual sample that we received.
Okay. And were you able to successfully complete your work in phase one?
Yes.
And did you generate a certain report at that time or the like?
Yes, the validation report. Yep.
Okay. So having completed your phase one work, is there a phase two that you undertook to do?
Yes.
And what was the goal, in phase two?
To measure the amount of denatonium benzoate in the sample that we received from the court.
Which again is the Powerade sample, is what you were informed, right?
Correct.
Okay. Now, were you able to perform that phase two work satisfactorily?
Yes.
And did you document the steps that you took?
Yes.
And was your laboratory able to reach any conclusions?
Yes, we measured denatonium benzoate in the sample that we received.
Okay. So the sample that you received, which was the Powerade sample now, was tested basically positive for denatonium benzoate, right?
Yes.
Okay. And then was there a next sort of part of the phase to now measure, okay, it's in there, but how much is it in there?
Yeah, we measured it 3 times. So what we do in this phase is take certified reference materials. We create what is called a linear curve Therefore, we take a certified reference material, which a different laboratory produces in pure form. We create several different concentrations, so different amounts of the denatonium benzoate. We inject all of them on high performance liquid chromatography with tandem mass spectroscopy. We measure the signal that we get from our created linear curve, so different amounts of denatonium benzoate as injected on the instrumentation. And we compare in triplicate dilutions of the sample from the court, the evidence sample that we received, and we compare it all at once to the samples that we prepared from certified reference materials. What we found was those three measurements came in at 116 parts per million, 112 parts per million, and 113 parts per million for an average of 114 parts per million denatonium benzoate.
Okay. And so at that point, did you prepare a certificate of analysis to document your work?
Yes.
And your conclusions?
Yes.
Okay. And do you recall the date that the materials were tested?
I don't recall off the top of my head, but it's here. I can look at it.
Your Honor, can he refresh his memory with this certificate of analysis? It's been provided.
Go ahead, sir.
The report was issued on September 17th.
Okay, 9/17 of what year?
2025.
Okay, and so basically you received the sample in June of 2025, is that right?
Correct.
And then we're engaged in the phase 1 and phase 2 testing in the late summer and early fall of 2025. And then, is that right?
Correct, yeah.
And then completed, documented, issued your report in September of 2025.
Yes.
And that date again was which one?
17th.
17th, okay. And that was, you took the average of the 116, 112, 113 parts per million, and that was 114. Is that how the 114 arrives?
Yes.
Okay.
I'm sorry, may I go back?
Yeah.
The date that it was tested, it's not an instantaneous process. It was from September 12th through the 17th. Is
okay.
Yeah.
So the active testing was in that
range.
5-day period
Yes.
or so. Completed, reported on the 17th
Correct.
of December 2025. And then, fair to say that you produced your certificate of analysis and your underlying documentation and work product to the defense team, correct?
Yes.
And what about the sample?
What about the sample?
Do you recall where that is right now?
There's pretty much none left.
Okay, so most of the sample was used.
Yes, it's used up.
In the testing. Right?
Yes.
And that's documented as part of it, right?
Yes.
Okay, so the number, the 114 parts per million of denatonium benzoate, what does that mean?
So parts per million is a weight-based measurement, which means that for every unit of weight of the drink itself, there are 114 parts per million of the denatonium benzoate. It goes from percentages. It's 1 part per 100. 1% is 1 part per 100. 1 part per 1,000 is 1/10 of that. Well, 1 part per million is 1/1000th of 1/1000th.
Are you aware of a Mass General law that applies that states how much denatonium benzoate is needed in antifreeze and engine coolant products that are sold in Massachusetts?
Yes, I believe that range is 30 to 50 parts per million.
Okay, so this score that came in
is
substantially higher than even that amount, right?
In our sample, yes.
Okay, and is it fair to say your amount, the 114 parts per million, is a measurement of the sample that you received in 2025, right?
Yes.
And does that mean that it had 114 parts per million if it was originally obtained in November of 2022?
Not necessarily.
Right, so that you're not able to test what were the conditions in 2022, right?
Correct. I can't do that.
You can't do that. You can just take the sample that was given and do the testing on that sample.
Only as we receive it, yes.
Okay. And again, that's the sample of the Powerade bottle that, from the Powerade bottle in this case, as far as you know. Yeah.
As far as I was told, yeah.
Okay. No further questions, Judge.
Mr. Camellia.
Thank you, Judge. Before I get started, I'm just going to borrow the stapler here.
So this guy goes to college. He does his thesis, his masterwork on weed. He's like,
Good,
I
morning,
need
sir.
some people to smoke something for a test.
So you were telling us a little bit about your lab at the beginning of your testimony, correct?
Then teaches
Yes.
at Jewish
And you mentioned that
elementary
you guys
school.
are accredited, correct?
Yes.
And then goes
Your
back to testing
accreditation,
weed.
however, only is for testing marijuana and cannabis products, correct?
It is for specific tests and specific analytes. Yes. Yes.
That are all, so my question was correct?
Yes.
Yes. Okay. So you're not a forensic laboratory, correct?
Correct.
You have no certification and no accreditation to do any sort of forensic testing, correct?
Correct.
And the accreditation process for a lab like yours is significantly different than an accreditation process for a forensic laboratory, correct?
I don't know.
So you don't even know what it takes to be accredited as a forensic laboratory, correct?
If it's ISO 17025, then I have a good idea.
Okay. So aside from the testing that you performed for in this particular case, all of your testing that you're accredited to do is for cannabis inflorescence, plant matter, cannabis concentrate extract, and cannabis infused products, correct?
That's what we need accreditation for, yes.
Now, you told us that you have some professional knowledge about denatonium benzoate, correct? Denatonium benzoate.
Yes.
All right. And are you familiar with the studies involving the use of denatonium benzoate to prevent people from ingesting objects that contain I'm just going to say the Bitrex because it gets a little bit long. Is that fair?
Somewhat.
Somewhat. Okay. So you are familiar with the fact that every study that has been done regarding the addition of bittering agents to household products such as antifreeze cannot be justified on any actual data, correct?
Can you repeat the question?
Sure. There's all of the testing that's been done regarding the addition of Bitrex to products like antifreeze show that Bitrex does not prevent any types of poisonings with antifreeze, correct?
I'm not sure I can comment on that. I haven't read every study, so I can't say yes or no.
Well, that would be one of the most important ones for regarding your testimony here today, yes?
Yes.
Yes. And so as one researcher who conducted a test into this stated, despite the appealing logic of limiting the ingested volume and thereby the severity of poisonings by adding adverse agents, and despite promising results in volunteering studies, bittering agents do not decrease the frequency or severity of antifreeze poisonings, correct?
If you say so, yes.
Okay.
Well, just a minute. You can just say whether you're aware of it or not.
I'm
and
not
if you're
aware.
not, that's the answer and that's the testimony.
Are you also aware, sir, that that denatonium benzoate is intended to deter the drinking of pure antifreeze, correct?
One of the substances,
Well,
yes.
Just in terms of, fair enough. We're just talking, just for purposes of this discussion, we're talking about antifreeze. Fair enough?
Understood. Antifreeze is, yeah.
Yeah, okay. So denatonium benzoate is designed to prevent the consumption of pure, well, not necessarily pure, but antifreeze.
Yes, yes.
Okay, and that's because antifreeze, ethylene glycol by itself is sweet tasting, correct?
Correct.
And one of the problems that people have had with it over the years is that it gets spilled on the ground. Animals will lick it up and essentially kill themselves.
Right.
Kids will drink it because a lot of antifreeze is bright colored and looks like Kool-Aid or sports drinks or whatever. Is that correct?
Correct.
Okay. And because it's sweet, it can be hidden in sports drinks or sodas or other sweet tasting drinks, correct?
I wouldn't know that.
You wouldn't. Are you familiar with the studies that show that when you add sugar to denatonium benzoate, the bitterness of the denatonium benzoate is markedly decreased?
I'm not aware of those studies.
Are you familiar with the studies that show that there has been zero impact on the number of ethylene glycol poisonings since bittering agents were added to antifreeze?
From what I've read, I have seen citations that said that there was not enough evidence. I'm not sure that I've read that there was zero evidence. It's just not enough is what I've read.
So you're not familiar with the fact that the poison control centers in the United States have concluded that the number of ethylene glycol poisonings have remained at the exact same level after the introduction of denatonium benzoate as before the introduction of denatonium benzoate to antifreeze?
I've read something to that effect, but I haven't delved into the numbers myself.
Okay. So what you've read in your studies of these things is that the denatonium benzoate does not have any effect on the number of poisonings for ethylene glycol.
That is a stronger statement that I can, I don't know.
Now, you said that the testing in this particular case was, for the sample, was done from September 12th to September 17th. Is that correct?
My notes say that the testing itself, the injection happened on the 12th, and then the report was issued on the 17th.
All right. So when you say the injection, what does that mean, sir?
In our process, we take an aliquot, a sample of a portion of the evidence sample. We dilute it to our method conditions that we validated prior to that, which then gets injected on our instrument, a high performance liquid chromatography tandem.
I was going to stop you for a sec. Not because you probably are answering my question, but I just wanted to know, you started testing the liquid that came out of the Powerade bottle on September 12th.
Yes.
Okay. So that's when you inject it into your machines, and we don't need to
measure it.
I know there's a very scientific process that I'm not smart enough to understand, but that takes about 5 days and ends on September 17th, correct?
It's a shorter process, but the data analysis and reporting may take longer.
So on September 17th, 2025, that's when you or somebody else that you will work with is able to interpret the data and determine that there's these 114, we're just going to say 114 parts per million in the samples.
That is the date that we issued the report.
Okay. And is that the date that, so at some point between September 12th and September 17th, that's when you were able to reach that conclusion?
Yes.
Okay. So if you weren't able to reach that conclusion until sometime between September 12th and September 17th of 2025, how was it that other experts hired by the defense had your results in July of 2025?
I don't know.
That would seem...
I mean, whoa! I doubt they had that result.
So did you know a woman named Celeste Waring was hired by the defense in this particular case?
I'm aware of Celeste.
And you provided your results to her so she could make her own conclusions from them, yes?
There could have been preliminary results while we were developing the method. There could have been some preliminary results shared, but not the final validated conclusive result.
So you shared your results with her before you even validated it?
I mean, I don't know. I would have to check my records on what exactly was shared, but we had multiple phases of the project where phase one was to make sure that we can see, detect, measure.
Sure.
We tried. Yep.
But that didn't measure what was in the Powerade bottle.
Not right.
That in September.
We did that in September. We measured using our validated method, and that's the result that we got.
So why was it that on July 28th, 2025, Ms. Waring issued her report in this case? How could she issue that report before you were even done with
Objection, Judge.
Let me see counsel at sidebar.
I'm sorry, it's getting spicy. We're trying to figure out how we got the results before you finished the validation of the testing method. It's a chicken before the egg situation. Only it's more like cart before the horse, and it would be bad. It would be very bad if the results were released before they had the testing method finalized. So let's see how much they're able to go into this. Obviously, the defense is not going to be calling this other lady that provided this information, and the state is trying to attack her the way they would impeach her testimony with this guy who they're connected to. Alternative scientific method. I ordered a chicken and an egg from Amazon. I'll let you know. Thank you. I'm Super T. Appreciate that. I have never been so full of Powerade in my life, guys. I mean, I can drink a lot of water and be fine, but lunchtime is not coming quick enough with the Powerade for some reason. It's quite hydrating. Not a sponsor. By the way, I got a good orange color now as well. Pretty happy with that one.
I'm not a camel.
Let's see, the Whiff and Jessica Hyde situation. Let's see if this is allowed to go into. I hope they're able to go into this because this is the first spicy bit we've had all day, and I like this kind of spice. Take an expert and hold them to an accountability. By the way, I got a phone call from a telemarketer. It was actually Maria from Great Vacations, and I said, "Hi, Maria. I'm actually on a great vacation right now. Can you make it quick?" And her response was, "I'm not a dog to do tricks for you, sir." And then she hung up.
Just so we're clear, none of that
Maria.
testing on the Powerade bottle liquid was done until September.
The final report was in September.
I'm not asking about the final report. I'm asking you told us.
Yeah,
you told the jury on September 17th you started testing the liquid in the Powerade.
September 12th.
September 12th. Sorry, Jeff. Thank you. September 12th, you started testing the liquid in the Powerade.
Well, I was describing.
You told the jury.
Judge,
he
needs to be able to answer
yes or
the
no.
question.
No, he's being. I'm going to permit Mr. Camellia to ask a yes or no question first, and then we'll see where that leads us.
You told the jury that you started testing the liquid in the Powerade on September 12th, 2025.
Okay, for that round, that would be correct.
Oh, so there's there's multiple rounds. Is that what you're saying?
No, I was describing.
I understand. You were
the
describing how
report.
testing was done.
He should be allowed to say what he's describing. Or the prosecutor is going to be testifying instead of the witness.
Mr. Scully, I understand how this is supposed to work. Place your question. Let's hear an answer.
Well, okay. Thank you.
Okay.
Go ahead. Say it again.
Let's answer the questions that I'm asking, though. Okay. So, did you start testing the liquid in the Powerade on September 12th, 2025, or was that not correct when you just said that?
Am I allowed to answer with context?
No. Did you start testing?
And if you believe that you cannot answer a yes or no question the way it's been posed, you can say that as well, sir.
I can't answer that question in that way.
So, the Powerade liquid. When did it start? When did you start testing it?
Is that correct?
That depends on what you mean by testing. May I explain what I mean?
No. No. Let's talk a little bit about denatonium benzoate, Powerade, and antifreeze. You're familiar with those three items, correct?
You could just use your
Yes.
words.
Okay. Antifreeze is a liquid, yes?
Yes.
Powerade, other sugary sports drinks like soda or whatever, those are liquids.
Yes.
Denatonium benzoate is a salt.
Powder.
And over the course of time, liquids evaporate, yes?
They can.
The denatonium benzoate does not.
Correct.
So as time goes on, if the liquids, if the Powerade, and I'm saying Powerade, but don't necessarily know exactly what that is. But I'm going to say Powerade just for ease of reference. So over time, if the Powerade was evaporating and the liquid and the antifreeze was evaporating, the concentration of denatonium benzoate in that solution, in that liquid, would be going up. Yes?
In that description, yes.
Okay. And when the defense expert came and took that Powerade from the state police in this particular case, he just poured it into a cup, open cup, like a little paper cup that you might drink a coffee out of. Would that increase the rate of evaporation?
Probably.
Not a particularly good way to transport or handle that type of evidence.
I'm sorry. I have no knowledge of what happened to the sample.
Well, I didn't
before.
ask you if you knew about it. I just asked you if that was a good idea.
I don't know.
So you are familiar, sir, with the fact that antifreeze, that denatonium benzoate is by statute in Massachusetts and by agreement with every antifreeze manufacturer in the United States added to antifreeze, correct?
That's my understanding.
So every bottle of antifreeze sold in a commercial store in the United States contains a bittering agent, whether it's denatonium benzoate or it's supposed to.
Okay.
Okay. And that in Massachusetts, you're familiar with the fact that it's supposed to be between 30 and 50 parts per million, correct?
That's my understanding of the law, yeah.
Okay. So that means if we have a bottle of antifreeze that's just antifreeze, the denatonium benzoate is 30 to 50 parts per million in that liquid. It's supposed to be.
It's supposed to be.
And people check on that sort of thing. There's testing that's done to make sure that the manufacturer is making it the way the law requires.
I don't know. I suppose so.
Every time you add something to the antifreeze, right, or you add the antifreeze to something else, you're diluting the antifreeze, right?
Yes.
Okay. So I got my little water bottle here that I've been drinking during the trial. If this is, we'll call it a half liter of water that's left in my water bottle, just for purposes of illustration, right? So if I add a half a bottle of water to a half a liter, sorry, let me back up. If I add a half a liter of water to a half a liter of antifreeze, I've now cut the denatonium benzoate parts per million in half.
Yes.
Okay. And so every time the antifreeze combined with the denatonium benzoate, something else is added to it, the parts per million of the denatonium benzoate goes down.
If that other component had no denatonium, then yes.
Right, thank you. That's an excellent point, right? So as long as I'm adding a substance to the antifreeze that doesn't contain denatonium benzoate, every time I add more substance to that liquid, the amount of denatonium benzoate in the solution goes down.
I hate to quibble, but the concentration goes down.
No, that's great. No, quibbling's great. So by the time you get to the point where you've now added, where the solution is 95% sports drink, for instance, and 5%.
Keep track of the coughs.
5%
I've got to take a break.
antifreeze. The parts per million of denatonium benzoate in the solution by concentration is now about 1.2 parts per million, yes?
What are we starting with?
We're starting with 30 to 50, right? So let's say 40. Let's say 40 parts per million. We'll take the average, right? So you cut antifreeze that has 40 parts per million in half with a liquid that doesn't contain denatonium benzoate. You're now down to 20 parts per million, yes?
In that scenario, yes.
In that scenario.
Yes.
You cut it 75%, you're down to 10 parts per million, yes?
Yes.
You cut it to 90% and you're down to about 1.2 or 1.3 parts per million.
Whatever that number winds up being. Yep.
Nothing further, Judge.
Mr. Scully.
Just a few questions, if I may, Judge. So the prosecutor was asking you a lot of questions specifically about antifreeze, right?
Yes.
I'm going to grab the antifreeze that was seized in this case off the exhibit table. Oh, I'm sorry.
The wiper fluid, the Rain-X?
Is there any antifreeze, Judge?
Yeah. I got some at home. That's
Some at home? Okay. So there's no antifreeze in this case. But maybe the source of the denatonium benzoate was antifreeze, right?
I guess.
You have no idea, right?
I don't know.
If it was antifreeze, there would be a law that says it's 30 to 50 parts per million, right?
Yes.
Is denatonium benzoate sold as a pure substance, 100% denatonium benzoate?
Yes.
Just hit a Google search and buy it. How many parts?
Yep.
Yes.
Yes.
How many parts per million in pure denatonium benzoate?
You wouldn't even describe it that way. It's a powder.
Oh, it's a powder.
Yeah.
But
It's a million.
right?
It's a million parts per million.
It's 1,000,000 parts per million. Okay. So your testing wasn't designed to figure out whether there was antifreeze used in this case, right?
Right.
It was designed to determine whether there was denatonium benzoate.
Yes.
What were your results?
That the results were that the sample that we received contained, on average, 114 parts per million denatonium benzoate.
Okay. And how confident are you in those results?
I'm confident.
No further questions.
Mr. Camilio.
No, Judge, I think we're done.
Thank you very much, Mr. Khan.
Thank you.
Mr. Khan. Jurors, I had an opportunity during what was your extended break to discuss with counsel the schedule, so we don't need to go to sidebar for me to fill you in. The defense will be making some final determinations about its final witnesses. I expect that there will certainly be at least one additional defense witness tomorrow. I don't think that's going to be a particularly long witness. There may be one or two others. That remains to be seen. I don't think there was a possibility of another Commonwealth witness. I don't think that's the case now. The way things stand right now, I think there's a very reasonable prospect that this case will be going to closing arguments tomorrow. So you should all come tomorrow prepared to be here for a full day, because as I told you, once the case is handed off to the jury, the length of deliberations excuse me, is entirely up to the 12 deliberating jurors, because you'll also remember that at the last stage of this trial, right before deliberations begin, 4 of you will be randomly selected to serve as our alternates. When that happens, we will literally take all of your jury numbers, put them in a little wooden barrel we have, and the scraper spins it around, and you don't win anything. Whether you lose depends on your perspective, I suppose. But 4 of you will be selected at that point to be alternates randomly. The other 12 will begin their deliberations. So they determine how long deliberations are. However long it takes those 12 individuals to resolve the issues in this case, as they see the issues, and to come to a unanimous verdict in this case is the correct length of deliberations. But so long as the jury deliberates on any given day, they deliberate right up until 4 p.m., and we provide lunch for our deliberating jurors on any day that they're deliberating through that lunch hour of 1 to 2, and we provide lunch to the alternates who are kept separately from the deliberating jurors. So tomorrow you should come with the expectation that if we get to the closing arguments, you'll start your deliberations and continue right up till 4 p.m. And and ready to return on Monday morning if deliberations are continuing, and forever, however long it takes, as they say, those 12 jurors to come to a unanimous verdict. So that's the way things stand. I know today's a relatively early day for you. Counsel and I still have some work to do because, among other things, we have to have what's known as a charge conference. I provide copies of my proposed final jury instructions to the lawyers, and then we have a conference about that where they can give me some suggestions, which I usually reject, but they have the opportunity to do so. Discussion, we finalize the instructions. So the other thing I'll remind you is tomorrow, when we finally do, if we do get to the closing arguments and the instructions, you'll have written copies of my legal instructions, so you'll be able to use those at that time. So this is a long-winded goodbye. I'm going to end it right here with my usual admonishment to all of you. You know what it is. Until we see each other again tomorrow morning, please don't discuss the substance of this case with anyone, including among yourselves. And please don't allow yourselves to see, read, hear, or overhear anything from any outside source about any aspect of this case. I want to thank you very much for your time and attention, and especially for your patience. I think all counsel really wish that all of the witnesses were available so there were no interruptions and we were just able to go up to 4 p.m. each day to get this case in most efficiently. It's really not within their control, the availability of some of these witnesses. And so once again, please don't hold any frustration against them or the parties they represent. Thank you very much, and we'll see you tomorrow morning.
All right.
Wow, that was loud. Well, you guys were here. First time I ever had to take a break on the live stream, and it's because I consumed all the Powerade. In the name of science, I might add. In the name of science. So many coughs, so little time.
We'll remain in session.
Bitrex is $30 a bottle for 55 milliliters.
Mr. Camillo or Mr. Strasnick, Ms. Strasnick, have you had an opportunity to take a look at the jury instructions?
I did briefly. There's another issue we can talk about after relative to one of the defense experts that I wanted to raise with the court, but I couldn't.
Oh, you can raise that now. Then we can deal with that first.
Let's do it now.
Mr. Lakin, who's on the defense witness list, at some point I thought that they had said he was going to be in the courtroom during the DNA testimony yesterday. So I reached out to see if that was the case, or if he was going to be testifying, because we got no report or anything. I was informed, based on my conversations with defense counsel throughout the trial, that if he was to testify, it would be in the area of transference and potentially questions about contamination relative to the swabbing that Ms. Hooper testified to, which is all areas that, despite not having a report, the Commonwealth was on notice of to some extent. Today, I got a written disclosure relative to Mr. Lakin's testimony, which I can provide to the court. And I have some serious concerns relative to areas that he now expects to testify to. I can tell the court I ran into this with him on a trial that I had about a month ago where he started testifying to things that we weren't on notice of. It was ultimately excluded, which is why I was hypersensitive to make sure that if he was testifying, there was a report. He wants to now talk about Bayesian statistics.
What was the first thing you just said?
I actually don't even know. But
What's it called?
Bayesian statistics. And I did make a copy. I can provide the notice I got to.
Bayesian statistics?
Yes, the binomial probability formula, odd ratios, probabilities, binomial distributions, random match probabilities, involving mathematical calculations, gene frequency calculations, population genetics, and assumptions under the Hardy-Weinberg model.
Whoa.
Which is just very different than transfer DNA or potential contamination. He does also plan, I guess, to testify on some of our DNA results. I just think that it's very different to be provided the notice of this type of witness with this type of testimony the day before he's supposed to testify, when that is not at all what was indicated about his testimony.
Mr. Norkunis?
Judge, the document we have here today, the first paragraph, in my opinion, is what I think we had talked about, he'll testify to. Then he has quite an elaborate background, and the rest of it was that what Mr. Strasnick just told, he's not going to do that, Judge. I don't know why that was added. I have no questions in that field. I don't understand any of those terms.
So you're not going to be asking him about, tell us all about Bayesian statistics and binomial probabilistic formulas.
No.
So you are telling me, Mr. Narkunis, you're going to stick to questioning him about what you've told the Commonwealth all along would be the subject matter, which is how DNA gets transferred, potentially?
Yes, essentially. He has quite an extensive background. I am going to ask him that, Judge. He's formed a lot of companies to do it. And it gives substance to his testimony as to what he's doing. His last paragraph, he actually says he agrees with the statistical assessment done by the DNA experts in this case. I haven't seen that, but come may ask him about that.
Okay, so yeah, I imagine they will. All right, well, on that representation, I don't think there's anything to discuss because I'm going to hold him to the subject matter that's been disclosed up to this point. The Commonwealth has been patiently awaiting the actual report.
Yep.
I'm glad this was brought to my attention. I think Ms. Strasnick will be prepared to deal with him in terms of the usual testimony about how DNA may get transferred. He starts straying into anything else, there's going to be an objection. I'm going to sustain it, and Mr. Narkunis is not looking to do that in any event, so that's fine.
I understand that, Judge.
Okay. Now, in terms of the jury instructions.
Judge, for the most part, they look fine. Two issues that I wanted to just raise that Ms. Strasnick actually brought to my attention. One, the court does have a section in here about prior inconsistent statements.
Yes.
I would also ask that the court add a paragraph to the end or its own paragraph in there about prior consistent statements, because we had on two occasions prior consistent statements being introduced or read into the record with regard, I believe, with Mr. Certainly one with Mr. Hawkins and the other one with Mr. Haywood. So I would ask the court add that at some point in there.
Well, the difference is, I don't think I've ever given an instruction on prior consistent statements, even when they've been elicited, is that the prior inconsistent statement explanation is to say that they have a limited use at a trial unless under oath or unless informed by the witness, because if not, they only go to the assessment of the witness's credibility, whereas a prior consistent statement, I didn't if it comes in as a hearsay exception, and they don't have that limitation, so I generally don't explain anything about it.
I understand that, Judge. I just think for a jury that is not going to be super familiar or probably have any familiarity with the rules of evidence in the hearsay rules, that sort of distinguishing between a prior inconsistent statement and a prior consistent statement could be difficult. So I would just ask that the court let them know that prior consistent statements can be considered for the truth and for any purpose that they decide to use it for. It's not limited like a prior inconsistent statement is.
All right, I'll consider that.
Thank you.
I understand the point.
Thank you. And then I don't know if I missed it. Just not a header for it. But in the evaluating the witness's testimony, you do. Okay, never mind. It is. So the only thing that the court's going to have for the expert testimony is just sort of the three sentences that are on page 30. Is that fair?
If so, there's a mistake. So let me take a look.
I just need a minute to catch up on that too. Page 30.
Oh, sorry. It's page 30 that seems to be. I think. Yeah, all right. I think that is actually normal.
Opinion evidence. I have in the copy I have before me.
Yeah.
I have multi-paragraphs.
You do, Judge. You judge, and we missed the entire expert part because there was not a separate headline for it. I do see the whole thing now.
It's listed as F, opinion evidence.
Yes, I know. We were just looking for a separate section for expert.
Oh no, it's part of the. Okay. But yeah, that's the standard expert witness instruction.
She said sorry like 4 times. Sorry.
Who's got the jury instructions, Mr. Scully or Mr. Scully? We had you brought to my attention yesterday the Bowden request, which but I'll hear whatever you wish to say.
Thank you, Judge. We would request that in this case. I think one of the issues with the instruction that we submitted, and there's a second instruction as well, sort of the modified Bowden, but we're asking for the full Bowden because we think this is a scientific case. And
ask for it in writing? I mean, I'm familiar with Bowden instructions, but I don't.
Oh, I'm sorry.
If you filed one, I don't have it in front of me.
I meant to hand it in. It's the model instruction 3.74.
That's fine. I'm familiar with the model instruction,
Right.
so no worries.
Yeah, I meant to hand that in. I don't think I did.
That's fine.
I had a false memory on that, Judge. So I think one of the issues that comes up is, are we entitled to this instruction? First, whether the omitted tests or actions were standard procedure or steps that would otherwise normally be taken under the circumstances. And in this case, what's interesting is that NMS Laboratory, the witness who testified, had only done one other EG case, the one in Los Angeles that he mentioned in his testimony. And the police, I think, and this is relative to failing to test for the bittering agent.
Right.
I think Trooper Williams, said in part, well, I did a Google search and there was, it's all over the internet. There's cases like the one with the woman who poisoned someone with antifreeze, and so we don't have to do that testing, right?
The death row one.
But there isn't really, I don't think, evidence that this would be a standard procedure done in these cases because there's not enough cases that people testified about. What's interesting, though, is that it's a matter of common sense. And I think the second phrase, or steps that would otherwise normally be taken under the circumstances, that's, I think, a determination for the jury to make. And the instruction is proper because the defense puts forth the argument that a fair prosecution would have taken these steps. An engaged investigation would have taken these steps to try to find out whether or not this bittering agent was in the substance or not. And obviously you've heard all about that. They didn't know about it at the time, but they were alerted at some point that it existed. It was on the de-icer label and so forth, and there's a general law, right? So we think because it's up to the jury to decide whether these steps would have been taken normally under the circumstances of this case, we would be entitled to this instruction, Judge.
All right. I appreciate the argument. What's the Commonwealth's position with respect to a Bowden instruction?
I would ask the court not to give a Bowden instruction, Your Honor. I think Mr. Scully just said to the court that these were not standard procedures or steps that would normally be taken, which is one of the sort of benchmarks of whether or not Bowden should be given as an instruction. Obviously, I can't remember the last time I tried a murder case that didn't have some sort of claim of Bowden on behalf of the defendant. It's a fairly standard defense tactic, obviously, and it can be effective used in the right ways. But I've also never actually seen a Bowden instruction given. So and I understand that is not what controls here. But the jury is going to hear in the closing arguments all about the supposed missteps of the Commonwealth or of the investigation. I don't think that this is a particularly egregious case. Obviously the Commonwealth disagrees quite strenuously with the way the defendant characterizes the investigation and the evidence, and so it really should be up to the jury to decide what weight to give it and how to use it in their deliberations. I don't see any basis here for the court to draw a special attention to it any more than any other part of the evidence here that the jury is going to be considering.
All right. Thank you, Mr. Camilio. I am not going to give a Bowden instruction. I did mention yesterday that I rarely give it. I think I can recall one or two occasions when I have given a Bowden instruction.
It's a big.
The case law tells me that the one thing I cannot do, and I have not done at all in this case, is take the Bowden issue away from the jury. This issue is squarely teed up for the jury. I expect it'll be forcefully argued in closing argument. It's been the subject of a fair amount of the examination of witnesses, all appropriately so. So the issue itself is, as I say, squarely before the jury. I have in no manner restricted that. The case law also tells me that the fact that I may have instructed the jury on the limited Bowden use of certain pieces of evidence that came in aid of the Bowden defense does not mean that a full-blown Bowden instruction and final instructions is required. And in fact, the case law says that a denial of a request for Bowden instruction is never an error. It's a matter of discretion with the judge. And finally, as I mentioned yesterday, it's really a disfavored instruction because it can be viewed as putting the thumb on the scale a little bit, drawing attention to a particular issue rather than just letting both counsel argue it based on the evidence that has been presented. The occasion or two on which I've given it, the investigatory lapses that were alleged were indisputable and so arguably egregious that in those cases I viewed a Bowden instruction as being warranted as a rare exception to my general rule. This is not such a case. It's, as I say, squarely and properly in front of the jury, and I expect it will be forcefully argued. But particularly, for example, listening to Mr. Kahn testify that he had to invent a test, come up with a protocol, and validate it for even testing for Bitrex, I'll use that phrase instead of the actual chemical name, tells me that it's something that is cannot have been expected as some sort of matter of course by the investigators in this case. So I'm going to deny the request for a Bowden instruction for those reasons, as per my usual approach in these cases, and all rights preserved for the defense. What else, Mr. Scully, in terms of the instructions? Anything else?
Can I have a moment to confer with counsel?
Certainly.
We got the microphone here, so.
All right, as they confer, defense is losing. That's what's happening right here. They're not getting to bring in things they wanted to.
I did look over your instructions. They otherwise look complete to me. So at this time, we have nothing further. I'm going to take a second, probably a fifth look at them. But
well, please do, because tomorrow morning, before we get together with the jury, the first question I'm going to ask you, Mr. Scully, is whether it's Ms. Church's decision to testify or not. Because, Mr. Narkunis, and I will ask him tomorrow morning, because if the decision is to testify, well, either way, I have to just make sure that I eliminate the prompt on that portion of the instruction as to the defendant not testifying. And if she doesn't testify, I have to take out the entire section. We have to do that and start making copies because it takes some time to do that. Okay. So I will just put that question to you first thing, Mr. Narkunis. All right. Mr. Camilio?
Two things. The first one I remember. Mr. Narkunis and I executed a stipulation tomorrow that we can read to this morning that we can read to the jury at some point tomorrow that just states that Ms. Church was charged with first-degree murder on December 22, 2022 in Salisbury, Massachusetts.
All right, let's mark that for an exhibit as an exhibit right now, and just remind me tomorrow morning. I'll read it to the jury, and I'll remind him what a stipulation is.
Thank you.
Exhibit 66.
Thank you.
Oh yeah. The other issue, Judge, is that the medical records in this case came in subject to redaction,
right.
Based on whatever rulings the court makes and the parties think are appropriate. So, two things with regard to that. We can take a crack at that this afternoon to the extent that everybody has enough time. We can look at them. But if Mr. Scully had indicated at sidebar earlier that he might read from them. So if he is going to do that, if I could just have notice as to what the passages are, so if they are things that I would be objecting to, we can deal with that before they get read rather than in front of the jury in the middle of it. If he's not going to read anything, then we just have to get them redacted before they go back, obviously.
I think that's fair and appropriate, Mr. Scully. If there are some passages from the various records that are in evidence that you wish to read, and I indicated to you, I give you the opportunity to do that. Please flag those because they may present a redaction issue. I don't get involved in redactions unless there's a dispute that I need to resolve. So I'm really leaving it to counsel, but that work needs to be done perhaps by the attorneys not doing the closings because once the closings and final instructions are given, I don't want the jury waiting for the finalized versions of the medical record exhibits. And I will deal with any disputes that come up and you bring to my attention. But Mr. Scully, if you'd think about that and just let the prosecutors know, so if they have an issue with any of the passages, I can deal with that first thing in the morning.
We'll do
Your Honor, thank you.
All right. That's all I have for now. Everybody's got a little time on their hands. All right. Thank you.
Too much time on our
Ms. Draper,
hands.
do we have probation this afternoon? Good. That's fine. All right.
Court, all rise.
Last cough gets us to 8:40. There we go, and the audio's off. All right. As I move all my Powerade bottles out of the way, these ones don't look very appetizing on this end. These ones are okay. Let me summarize a little bit. The defense wanted to do a couple things in closing or right at the end of the case. They wanted to play a Facebook looking back at memories type video that sort of the Facebook account makes for you if you take a bunch of pictures over a period of time. They're like, hey, we've created this fun video for you to share with your friends to remind them to use Facebook too, because you're not using it as much as you should, or whatever it is. It's basically trying to draw people into Facebook, and it's auto-created. It's a bot that goes out there and just pulls a bunch of pictures and puts it to music and it's a little motion and stuff on it. And you're like, oh, that's cute. Those fun memories. I haven't looked at those in a couple of weeks. They wanted that video to come in because it was on her phone. That's not coming in. The defense said it was on the phone and they confiscated her phone. We should be able to bring it in. No, it doesn't work like that. It was outside the scope of the search warrant. The police didn't even look at it, so they can't authenticate it. The judge says, oh, it's not coming in just standalone. You just get to play this if you want to play it. Obviously, if Judy gets up on the stand, she can authenticate it, and you can play it then. That's not going to happen. Judy is not going to be testifying. And if she does, wow, this is going off the rails again. But so that was out, and then we also had they lost this last little battle as well about the Bowden defense, where they get to basically say the police screwed up the investigation. Had they been competent, had they done what any other reasonable investigative body other than Canton would do, they would have done this, and they didn't. And that's for to basically tell the jury, look, this evidence is flawed. They're missing all sorts of stuff because they just screwed up. It was like gumshoe investigation. It was terrible. That's not coming in. They're not allowed to have that instruction read to the jury. That really ticks them off because that's basically their whole case. That and the bitter stuff. The bittering agent, by the way, you can buy it. It's some of its more common uses are to test to make sure the gas mask you're wearing in like a laboratory environment has a proper fit around your face. How do you do this? Well, you put your gas mask on, then you put your hood on, and then you spray the stuff under the hood, and you breathe. And if you start gagging and throwing up, you need a better fit. So $30 for that. I'm not going to buy any. It's the bitter Bowden defense. But yes, you can buy Bitrex just on Amazon, and they'll ship it to you. It'll be there tomorrow. Potent stuff. When they say parts per million, like a couple parts per million, count out 1 million of anything, like a million drops of Gatorade, and that's you've got truckloads at that point. And then add 1 drop of Bitrex. That would be a 1 to 1 million ratio. Or add 43 drops of Bitrex. And that's bitter enough that no one would want to drink it. It is potent stuff, some of the worst stuff on earth as far as taste goes. All right, if you suspect your colleagues are taking your food from the work fridge, yes, there's another good use. I like that. I approve. By the way, I did research this. First I reached out to Bitrex.com, which is a company in Scotland that makes this stuff. And then I saw that I could just buy it on Amazon. So I'm like, never mind. But it's in the amounts that it's recommended to be included in a lot of these substances. It's not deadly. It's not bad for you. It's even it's okay for pregnant people to have. Anyway. So it's okay to test with. Comes in a puffer form as well as a spray. Yep. And it stinks. It's bad stuff. It's yucky. I think the one the smoke ones, the puffer ones, they might be a different substance, but it's also right up there with nasty smell. What is that? What is it in fingernail polish that makes you stop biting your nails? Germs? I don't know. I don't use fingernail polish very often. Let's see. Got too much time on my hands. Made little differences if they made us take it off anyways. Wipe the face with Fuller's Earth. Stings if you don't get with. Yeah, terrible stuff. Leroy was in a lot of pain. That is apparent not just on the videos, but just from the description. As we go from stage 1, stage 2, stage 3, your body is shutting down, but you're still alive. But your brain is swelling. Your kidneys are failing to do anything. And so everything's backed up and broken. Your blood is acidic. Okay, you're basically on fire on the inside. Terrible, terrible way to die. No, there's a special fingernail polish that is bitter. People use it when they have a nail biting habit. Was she poisoning him over time? That is something the state has alleged, that he doesn't feel good when he's with her. And when he's away, he feels good. Like he's sick when he's with her and not when he's away. So it's possible that they're going to say in closing that we believed that she was doing this over time and then just gave him a big old dose at the end. If you put fingers in your mouth, I'll put chicken poo in your fingers. Okay, that would work. That's one way to do it, Camilla. I've always said, teaching kids that bad substances are bad, and in any quantity. I've told them how much dog doo-doo is okay to have in your cookies. Like, if it's small enough, how much is okay? And the answer is none. You don't want any. If you know what's in there, you're not. It doesn't matter if you can't taste it. You don't want any. But let's see. Why didn't they use syrup of ipecac? They used it on kids. Ipecac, a fun factor. Where I went camping, there was ipecac plants, I think, grow natively or something. One of the campgrounds is called ipecac.
Call from.
Unholy Saint.
To accept, press.
Hey, this is RA. Who's on the phone? AWOL?
Unholy Saint.
Unholy Saint. Okay. How are you doing?
I'm doing good.
Good.
All right. So my wife is a QA director. She works with veterans.
All right. Can she get me a sample? Never mind. Go ahead.
She's tasted it before. She says the most bitter thing she's ever had. It actually makes your mouth numb for the entire day. You can't taste food.
Oh, man.
For it to be that bitter, it had to have been diluted a lot. Or he was under some type of drug or something. But the prosecutor said that they think they diluted it down to 95%, right?
Okay.
That wouldn't change the color, right? You proved that.
Right. Well,
the color would not change the orange.
Our test isn't really scientific. Obviously, the viscosity of the material, the different liquids and everything. There's other issues at play. I think those issues are actually a bigger deal that should have been tested for, weren't included in this trial. Say, for instance, you've got heavy syrup and light juice. So the syrup is the antifreeze and the juice is on the top. If you're drying some out, you pour some out. You're changing the mixture ratio, right? Because the top stuff pours off first and the bottom pours off second. So if it's allowed to settle and it comes out of separates like your Italian dressing does in the fridge if you don't use it often enough, just pouring some off the top without shaking it completely changes what was in there. So we don't know what happens. Those numbers, just not sure.
All right.
Anyway.
Yeah, that's crazy, but that stuff's really bad.
Yeah. So so you'd know if your wife was giving you a little bit of antifreeze, because.
Yep. No, she wouldn't do that.
Right. Good. That's good to hear. Unholy Saint, that's awesome. It's good to hear somebody who's got a little bit of experience with that. So thank you very much. All right.
Nice talking to you.
See you later. Bye. All right. Let's see. If he was doing coke too, he probably wouldn't taste that much at times anyway, right? I think in this case, the thing that's done it for me is that message saying, I want to poison somebody. I've got somebody picked out. That takes a special kind of twisted to get to that point. That you've planned out and you've thought out, I want to watch someone suffer. It's not like I want to see someone, lights out, end their life. I want to see them the last moment of life. It's like, I want to watch someone suffer and die. That's what she said. I've got this person picked out. I can't wait. Scorpion, I'm going to sting, watch the suffer. It's going to hurt. That's what I want to do. That's a tough one. That's going to be, the jury's going to be like, oh yeah, where's that verdict form again? All right. I think that ends it for the day. That is what made my non-interested hubby say, she's guilty. Yeah, that's some pretty rough evidence to try to overcome from the defense standpoint. All right, anything else we need to talk about today before I try to finish all these bottles of Powerade? Which, by the way, everything in here is Powerade. It's just different colors of Powerade. We started with yellow, some orange, Powerade Zero, which does not agree with my tummy. Just let me tell you, don't like the non-sugar version. I need the good stuff. Fruit punch, and then mixtures in between. My non-interested, let's do a poll of non-interested hubbies. Apparently, so far, 100% say they're guilty as heck. So you could open up a Powerade bar, pay a kid $5 to drink some of those. My kids already came in and grabbed the unopened ones. They were out weeding the flower hill out in the parking strip thing, and they wanted some Powerade, so they've already got those. How's your A1C? I don't know. I probably should do a little pinprick and test it real quick. Are we done for the day? We're done with this trial for the day. We are coming back for the podcast tonight, 8 p.m. It's called Berm. I called it the Mound. We call it the Mound. Our parking, our driveway is like one of those circular driveways you can like pull through. But really, there's just like two driveways that are sort of connected at the top. We never pull through because it's not very wide right there. But we've got this place that used to be, it's a circle that used to be where a big, huge, I don't know, pecan tree was or something. It was massive. It was huge. And there's room to park 2 cars on one side of it and 2 cars on the other on pavement, on asphalt. Or no, on concrete. And the owner before us cut down that tree and then just piled up dirt around the stump. Instead of taking the stump out, just piled up dirt around the stump and planted flowers on it and called it good. And so we're constantly trying to make the mound look good by weeding it and putting like weed suppressors on it and planting other flowers in other areas and then covering it with bark. Right now we're doing the cover with bark thing. What are you going to do for the rest of the day? If we don't have a portal, we won't be back, y'all. Waiting on a verdict for Massachusetts versus Fitzsimmons. I tell you, the closing in Massachusetts versus Fitzsimmons with one of the lawyers waving around the pew and racking it and pointing around the courtroom, that was enough to get people a community strike, violation strike. So Trial TV Live dealing with that issue, trying to fix it with YouTube as that happened in the courtroom, and they were covering that case. So, man. So, yes, we're planting our bark nuggets today, our red bark nuggets. The nonpolar oily substance goes to the top. That would be the ethyl glycol floating above the Powerade. T-shirt. Everything I know about antifreeze I learned on Recovery Addict. I didn't buy any antifreeze today. I was so close. I'm standing there at like, I don't know what it was, Checker. I think it was a Checker store. And the lady's like, "Can I help you with something?" I'm like, yes, but it's going to sound really bad. And she's like, what do you need? And I said, well, I need to buy some antifreeze based on the color it is. And she's like, what is it for? Like, meaning what vehicle is it for? Is it like a diesel engine? Or are you doing what is it for? I'm like, well, it's for a taste test, but we're not going to be tasting it. We're just looking at the colors and then throwing it out. I thought better of it only because antifreeze is one of those chemicals you don't just dump down the drain. You have to dispose of them properly, and I didn't want to have a whole bunch of antifreeze that I had to now dispose of ethically in a environmentally safe manner. So we did not buy any antifreeze. You are allowed to lie. I can't. I have to tell them the truth. She probably called the cops on you. I explained it was that we're, YouTube, we follow court cases. There's a court case where it's suggested that antifreeze was used mixed with a drink, and we're trying to find out if it's possible to get from one color to the other, and that's it. Wow. Okay. It's like bacon grease, just run hot water when you put it down the... Clever name. No. I've seen whole kitchen plumbing systems have to be replaced because of this. Tell me you're renting without telling me you're renting. That's what I see right there. Just in case we're coming back, sent something to Mod Chat. Let's take a look here. See what we have. 44th, huh? I heard Judge McNally, Judge Dad, had a wild one recently. Was that the lady that insisted she was not driving a car, even though she was driving the car and you could see her driving? Was that the one? I need to find the original on that. That's the one? Oh, my goodness. And finally the judge is like, show me the driver. Show me the driver. And she's like, I have to first ask their permission. And she's like getting out of the driver's seat and getting out and walking around. Oh, it was so bad. It was so bad. We might watch that after lunch. But I can't. We've got the podcast tonight. We've got the podcast at 8. We'll be back for that one. We haven't covered Fitzsimmons, so we're not covering the verdict. That would not be fair of us. It's confusing to a lot of people. If I played the verdict music and then showed a verdict in a case we hadn't followed, it would just be crazy. Save the McNally while we're on verdict watch. Yeah, that would be a good one. To your mount. I'll do that. Greeners, what are you sending me? Like creepy clown faces on Mod Chat. Okay. No spoilers, please. Yeah. Nobody say the verdict. Nobody say the verdict. I know some of you are going to watch it. You're saying it just because you have it on screen. It is Podcast Thursday. We're going to have a podcast tonight at 8 p.m. I don't know if we're going to come back this afternoon. Yeah, make some other plans. Mrs. R.A. has a list of things to do. One of them involves me climbing up on a ladder and working high above my head near the ceiling. I'm not sure how that's going to go. I will tell you that I have an appointment with my chiropractor and acupuncturist on Monday at 3 o'clock, so we can have no verdicts at that time. Monday, 3 o'clock, I have to go to an appointment. They're going to do I'm going to be like a human voodoo doll, I guess, is what they're going to do. It might fix my arm. So, tonight when you go home, please hug the people you love, smile at someone to make that day just a little bit better, and please stay safe. We go live again tonight at 8 p.m. with the podcast. Please join us. It's going to be a lot of fun. And then, of course, we'll be back tomorrow with the end of the defense case, closing statements, and maybe even verdict watch in the Judy Church trial. So that'll be awesome. Monday's my daughter's birthday. 50. Holy cow. That's awesome. You guys stay safe. Have a good day. We'll see you a little bit later. I might do a members only live because I have to do a couple of those. I'm late. I'll catch up. We'll see you guys. Bye-bye.
I'm going to sustain my own objection.
Thank you, sir. You're my new best friend.